Okay, I think that's my cue. Hi, everyone. My name is Luke Martin. I am going to be your presenter today, and I'm going to be talking about starting a business. The title of the presentation is Where Do I Start? Oftentimes, people are so confused as to where to start with a business, and so this presentation is designed to kind of give you a little bit of insight as to what it actually is to start a business. I have the absolute pleasure of being joined by my colleague, Anne Tran, Leanne, and she is an amazing boss. You probably have dealt with her before if you've ever called into CAMFT. She is amazing, and she is going to be answering our Q&A today. So if you have any questions, feel free to go ahead and send those questions to her. It's more work for her, less work for me, so I'm A-okay with that. Okay, so if we are going to go ahead and get started, the first thing that I want to do here today, as a lawyer, I feel obligated to do so, and that is to provide a disclaimer. Basically, what a disclaimer is a way of kind of getting out of trouble for lawyers. And so this information provided in this workshop is for educational purposes only. It is not intended to serve as legal advice or to act as a substitute for legal advice. So if you are needing legal advice or you have further questions, you may call into the CAMFT legal line if you are a member. If we are able to answer the questions, we will be more than happy to answer them. If we cannot, then we will likely advise that you speak to an employment attorney. An employment attorney or a business formation attorney. There are some that specialize in business formations, and since this is a business formation presentation, that may be the best route to take. So a little bit about me. Here is my bio. So if you are interested in learning a little bit more about me, that is where you can learn more. The reason why I did this presentation is because when I had my own business practice, I worked with an organization in establishing businesses for real estate investors in foreign countries. It was quite complicated because I was having to deal with a lot of language barriers, time zone issues, as well as some really complicated business laws that were in place for California businesses. And so I kind of became a little bit of an expert in this area. So I figured I would share my wealth with all of you. So what are we going to be doing today? We're going to be looking at 5 things today. We are going to be looking at how to organize yourself and your business, how to create a business structure and to name it. Once you have your business structure, you may want to hire an employee. That is going to be something that, a lot of businesses that are wanting to grow will do, and is really important to make sure that you do correctly, because in California, we are a very employee-centered state. And so there's a lot of laws that an employer can get themselves into trouble with if they don't follow it exclusively. Finally, if we are, well, I shouldn't say finally, next is if we are going to hire somebody, we need to know how to get out. So we're going to be discussing ending an employment relationship. And then finally, we're going to need to be able to know how to store all of those records, how to store them, where to store them, how long to store them. So that is what we are going to be covering today. And we do have one break today, so that is going to be at 10:30. I will do my best to kind of figure out where a stopping point is at 10:30. That's really going to be dependent upon all of you as to the questions that are being asked. And then we will resume at 10:45. So without further ado, let's go ahead and get started. And that is figuring out where to actually start, okay? So this is what I think is the best place to start, is to basically come up with a plan, okay? And this plan is usually a 10-step plan. First, create a plan as to what the business is going to be, then anticipate startup costs, figure out the business structure, get an EIN and NPI number, get a business license, set up a bank account, create intake forms, build your team, advertise, and then record keeping. That's kind of the big overarching. So if you're one of those individuals who are at home trying to figure out where to start a business and you're taking notes, that is the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 that I would put down on my piece of paper, because I think that does a good job of overviewing the entire presentation as well as what you need to be able to do. What I will say to that, though, is that this presentation is A, going to be recorded. B, you should be able to have a copy of this presentation. So don't feel too stressed. There's going to be a lot in this presentation. So if you miss something or something goes by too fast, don't worry, you'll still have access to it. So what do I mean when I say create a plan? Now, this comes directly from the Small Business Administration, or the California Small Business Administration. They basically state, create a plan where you know the purpose of the business. What are you trying to sell? What is your end goal? Why is your business unique? How will you finance your startup cost? So this is not just a general overview as to, what are you doing? To me, this is kind of that, I have an idea and I'm now going to put it on a piece of paper to kind of make it make sense. When you're doing that, the first thing that you should probably do after you have an idea is to actually research it. Is this going to make sense? So conduct research. The US Small Business Administration, the California Small Business Administration, there are plenty of organizations out there that have great research already completed and available for you to be able to kind of know the demographics of your area. Is there a reason to start this business? For example, if you are wanting to do play therapy, it may be helpful to know if there's any children in your area. If you're in a predominantly senior citizen community, having a play therapy business may not make sense, right? So that's why you really need to figure out your market, understand, what it is that people need in your community and in your area. And it may be something that you already know because that's why the idea came to your mind. But it also is something where just because it's an idea doesn't necessarily mean that it's the correct idea. So that's where that research really comes in to make sure that you are creating a business that is going to be fruitful and successful. And I know this is kind of morbid already to start with. You always need to come up with an exit strategy for any business. So when you start a business, you have a great idea, you need to make sure that you have an exit strategy set up and in place. And I know this is just kind of the planning stage, but even at that planning stage, it's really critical to know, okay, if this business doesn't work out, imagine you're an associate and you're working at an organization, you decide, I'm going to start my own private practice. Great, super exciting. Do your research, start your business. But also think, okay, this business may not work out. I may not get clients. I may not make enough money. What do I do? What's my plan B or plan C or plan D, whatever it may be? Make sure that you have that in the back of your mind, just because, sometimes businesses don't work out and you don't want to pigeonhole yourself into being in this business only when there's so many other opportunities out there for you. Okay. Startup cost. Okay. So the idea is you have to spend money to make money. So the idea that, you're starting a business, you got to have capital. So if you need to go borrow money from mom, if you need to go take out a loan, don't be afraid to do so, because in order to be able to start a business, there's going to be startup cost. You got to figure out where you're going to have your business. Are you going to do it out of your home? Are you going to need an office space? Okay. Do you have a desk? Do you have a plant? Because every office needs a plant. Do you have office supplies? Do you have professional supplies? Do you have your license, insurance, renewal fees, advertising costs, and then unknowns? There are so many things that go into starting a business. It's not like you can just start a business and it'll work out perfectly. You do have to have some money saved up because, in order to be able to have a business altogether, there's going to be startup costs. And so make sure that when you are starting that business, that you do have that in mind. Okay. Now, once you've done the research, once you've purchased your plant, now it's time to figure out, okay, what kind of business do I want to do? And generally, as an LMFT, there are three business structures that you can have. It's a sole proprietorship, a general partnership, or a professional corporation. Those are the three. Now, I'm going to try to field off some of those questions for Anne, but a lot of individuals always ask, can I form an LLC? The answer is no, you cannot form an LLC. Now, we'll get to that a little bit later in the presentation, but I'll give you kind of a spoiler. Now, with that in mind, if you are establishing one of these three businesses, it is very important to recognize that there are pros and cons to each one. Tax liability, general liability, and what the legal protections are for these organizations are all things that you need to think about when you're choosing the right organization. Let's go forward. Next is EIN and NPI number, and this is pretty self-explanatory. So in order to be able to establish a business, you do not need an EIN number, but you most likely should get it. It's pretty easy to get. You can go on to the IRS's website, you can begin an application, and within 15 minutes, you generally will have an EIN number. Relatively simple. You do need a social security number in order to be able to apply for an EIN number. If you don't, if you have a TIN number, that's where that knowledge from those foreign investors, you can obtain an EIN number. It's a bit complicated. It's a whole fax process. Dealing with the IRS is never easy, but it is a possibility for you. So if we do have individuals who don't have those social security numbers, fear not, there is options. But this is a great way of replacing your social security number when you have to give your business information out. In addition to the EIN number, if you are going to be a provider, obtaining an NPI number. Now, individuals who are associates can apply for an NPI number. Licensees can apply for an NPI number. It's generally something that you want to get right away. The reason being is because it's a unique identifier for third parties who use NPI numbers, usually insurance companies. And you may be thinking to yourself, well, I don't plan on working with insurance companies. Cool, great, no problem. I hope your business is going to be successful as a private pay. Usually in a private pay establishment, you still need an NPI number because you provide super bills to your clients for reimbursements. If you don't provide an NPI number, you may have to provide your social security number as an identifier for insurance companies to have you have your clients reimbursed. Oftentimes, that's a little uncomfortable to provide a social security number to your client. Wouldn't recommend it. Obtaining an EIN and an NPI number, pretty easy to do. And it's also something that will really, it's more common business practices. And so that's why it's recommended to obtain. Next, okay, so you've thought about a business, you have created that business, and we will talk about business formation a lot more, so don't worry, that's why I breezed by it. You have then got your EIN and your NPI number. Now, what else do you need to do? Okay, well, in order to lawfully operate, you most likely will need a business license or a business tax certificate. The names are kind of are synonymous with each other in the legal field. It really just depends upon the county or the city that you are in. They will tell you exactly what you need. If you have no idea, which you probably don't, right? Because who knows what business license or business tax certificate they need when they're just starting. This is an amazing website that I highly, highly recommend for everyone to take a look at. It is the CalGold website. Dealing with the state of California, dealing with the federal government can be complicated, but I do have to hand it to them. They made an amazing website, which makes things so much easier. It's just calgold.ca.gov. what it does is it sets up essentially a website where you can type in, select your city or county, enter the business type. I would recommend general business information as the business type. And then what it will do is it will provide any and all permits and licenses that you may need. It provides a link to the actual department, the phone number, the website. It makes life easier. So instead of having to Google, like, do I need a business license? You can just go to this website. It'll tell you if one is needed in your area and where to go to get it. So highly recommend calgold.ca.gov. Now, a lot of individuals are underneath the impression that, well, I don't need a business license because I work from home. Uh-oh. Unfortunately, cities and counties, as well as the state of California, are well aware that most businesses are moving in that direction. So this is a business tax application in the city of San Diego, which is where I am. And so if you are, this will be really easy for you because you'll be able to see it. If you're in a different county or city, you will have an application that is similar to this. There is a new question. I don't know how new it is, but there is a question on there that asks, is this a home-based business? If yes, residential address must be listed as the business address. So unfortunately, even if you have a business that is predominantly at home, you still may need a business tax certificate or a business license. The city and the state want their money, and so this is a way for them to be able to get it. So definitely take a look at that. If you need it, great. If you don't, there are some unincorporated areas in California where it's not required. It's just best practice to go ahead and take a look to see if you need it. You most likely will, so keep that in mind. So after you get a business license, what do you do next? Well, you got to figure out where to put the money. And that's really going to be dependent upon you. Most banks have business accounts that you can easily open. To open a business account, you're going to need an EIN number. You're going to need your business formation documents, the ownership agreement, and that business license. Now, here's the one thing that I will say about bank accounts. It depends upon the business structure that you're going to do as to what account that you need. If you are opening a professional corporation, well, legal protections are afforded to professional corporations so long as there's not commingling of funds. So what that means is there needs to be a clear distinction between your bank account and the bank account of the business. If so, there's no commingling of funds, there's no piercing the corporate veil, legal protections remain in effect. Now, if you are a sole proprietorship, that's where things get a little bit interesting. And the reason why I say it gets a little bit interesting, and again, we'll cover this a little bit, but there is no distinction between yourself and your business. And because of tax filing purposes, there really is no general need to have a separate business account. Now, it's best practice to, so that way you can clearly see where the money is going and coming in, going out, what you're paying yourself, what you're paying your business. So I would recommend it, but it's not a legal requirement. There are often times when counselors who are just starting, they will, get a $500 check from their client and they will directly deposit it into their personal bank account. Now, big no-no if you're a professional corporation. If you're a sole proprietorship, maybe okay. I still would recommend obtaining a separate business account just because, it's cleaner that way. And your CPA or tax accountant, whoever is handling your taxes, probably you, will love it because you'll be able to see the clear money going in, money going out. But that is ultimately up to you in your discretion. Now, again, this is just formation. I mean, I know this isn't the fun stuff because, the whole fun stuff is actually setting up, a business to be able to have clients, and that's where the real positive movement is. However, it's really important that you focus on this kind of stuff at the very beginning. And one thing that I highly recommend is to make sure that you have malpractice insurance. When you are starting a business, usually you're just starting out, you're green, and you're more susceptible to making mistakes. Happens, that happens. And I say, if you make a mistake, own up to it. You have insurance, you're going to be okay. If you don't have insurance, that's where it gets scary. Okay. So make sure you have insurance so that way you don't fret too much. You don't have those sleepless nights by making a mistake. I can't tell you how many business owners that I've talked to where they've set up a business. They go, oh my God, I made a mistake. I'm going to be sued for the rest of and I'm going to ruin my rest of my life. Don't worry about it. If you have malpractice insurance, that is what that is there for. That is your pillow at night that will help you sleep at night, knowing that, mistakes happen. Don't try to make the mistakes, but if they do, you at least have some level of protection to be able to sleep soundly. Now, what most individuals do not realize when they're starting out is that there's not just one type of insurance, there's two. So there is malpractice insurance, which will generally cover you for performing services. So if a client is injured by something that you say or something that you do or a recommendation, that is where malpractice will step in and they will potentially cover any legal issues that are surrounding that. If, however, a client is injured because of something that is not in actually performing professional services. So let's imagine that you have a lamp and the client trips on the lamp. They trip on a rug, they get stung by a bee. All of these things that don't necessarily have anything to do with you actually giving therapy to someone, that is when you will need general liability insurance. So general liability insurance, slip and fall insurance, premise liability insurance, all of these are synonyms for each other. So depending upon who you are talking to, they may call it something else. But essentially, this is, generally, if somebody gets injured at your practice without you actually having performed services, this is what has you covered. Think about it with Walmart or Target, whatever your preference is. Somebody spills a drink, they walk down the aisle, they slip and fall. Guess what? That is where general liability insurance will come in and take over. I put a little logo here. I don't know if you can see for CPH and Associates. Ooh, that's a little bit blurry, but the reason why I do that is because if you are a CAMFT member, make sure that you reach out to CPH and Associates and let them know that you're a CAMFT member, because they are going to likely provide you a discount. I can't guarantee it, but I do believe that discounts are offered with CPH and Associates, and that is one that CAMFT has reviewed and believes does have great potential for insurance. So look at that. I believe CPH does have both malpractice and general liability insurance. So plug for them. Okay, almost there. We're at stage 7 out of 10. So we're almost there as to actually seeing a client. So once you have, set up your business, once you have a bank account, so that way you can accept money, once you have insurance to make sure that you are legally protected, the next thing to do is to create intake forms. You, if you are a CAMFT member, are extremely lucky because CAMFT has created quite a few sample practice forms. Informed consents, releases of information, no secret policy, intake questionnaires, really anything that you could imagine that you need to be able to start a business is there, excuse me. So I would highly recommend it. Now, you do need to be a CAMFT member in order to be able to review these intake forms. You can simply go, once you log into members only private practice corner, and there are quite a few different forms. There's also additional information about setting up your private practice, HIPAA forms, marketing, billing, will writing even. So we have you covered for whatever you need. These are all templates. So you are able to take this, download them, tweak them for your business practice. If you need further assistance with that, I would highly recommend speaking to an attorney about that, just because these are going to be personalized for you and your practice. And that is something that, your own attorney would need to be able to help you with. So hopefully that's going to give you a leg up. Oftentimes, and I will just say this is personally true, if you are starting a private practice, taking the paperwork that you had from prior organizations and using it, not copying it exactly, but utilizing it as a template is another way. I would always recommend personally, and what I would always do is have two forms, I guess is the best way to describe them, on a screen and compare the two. What I like from one, I would copy and paste. What I like from the other, I would copy and paste, and then kind of make this big, huge amalgamation of one form. Nothing wrong with that. Okay. Build your team. Okay. Again, we're not even there with your clients yet. What do you need help with? Okay. Are you good with numbers? If you're not, then you probably want somebody to help you with the money coming in and the money going out. Do you have to pay for things? Do you need an office manager? Do you need some help with the amount of clients that you believe that you're going to have? So building your team is something that, if possible, would be ideal before even seeing any clients. Having that infrastructure to make sure that that business is secure and can grow with your clients is always optimal. So no right or wrong answer there as to building out your team. It's usually riskier when you're just starting out to have team members. So this may be something where it's in your 5-year, 10-year, 20-year plan where you want to build out your team. Now's the time to be thinking about that. If you do not have any interest in having any teammates or employees, perfectly fine. Nothing wrong with that. There are plenty of practitioners out there that have been working for hundreds of years. I say that loosely, and apologize if that offends you, anyone. But there are plenty of people out there that have had a long, successful career where they have never brought anybody in. There's nothing wrong with bringing anybody in. But if you want to, great. If you don't, no problem either way. Begin thinking about it. We will be talking a little bit more as the presentation progresses about how to actually hire an employee. So if that is something that you are looking at, considering, again, part of your 5-year plan, got you covered in this presentation. Advertising, okay? How do you get clients without advertising? You really can't. I mean, I guess there's word of mouth, and I guess if you have clients existing from your associateship and you want to bring them over to your actual new private practice, you can. So that is something, but most businesses need to advertise. And there's several ways to advertise. The most common is to have a website, have a phone number. Do you want to have a phone number that is your personal phone number, or do you want to have a business phone number? Do you want a personal email address, or do you want to have a business email address? Business cards, letterhead, offices, signs, brochures, flyers, TV, radio, billboards, however you want to advertise, you can. But remember at the onset, when we talked about it, you have to spend money to make money. This is also part of that. So, I mean, a website isn't free. Obtaining a secondary phone line may not be free. Business cards are definitely not free. Office signs, letterhead, these things cost money. So make sure that you're aware of that. Now, here's something that I will share with you just because I think we have probably a lot of associates on the line. Is it appropriate for an associate to have a website? Yes, but there is a big asterisk with the yes. First, it is at the discretion of the supervisor as to how they advertise. And then second, you have to make sure that it's not false, misleading, or deceptive. So if you are lukemartintherapist.com, and I'm an associate, that's a problem because using the term therapist implies that I have a licensure. So that's why starting a business as an associate or pre-planning it is important. I don't think it's appropriate, maybe I wouldn't say appropriate. I would say maybe it's something to consider waiting to go live until you're actually licensed, though. Okay. And then finally, record keeping. So even before you have a client, or as soon as you get a client, you have to secure the record and keep it for 7+ years, depending upon the type of client. So just imagine you haven't done anything. And in order to start this business will not leave you for at least 7 years. Okay. So really think about establishing a business. Is this something that you want to do? Is this something that you want to have follow you for the next 7 years? Because it will. And that's just the reality of starting a business. That's not to scare you away from starting a business. There are many, many positives, personally and financially, for having your own business, but it is something that you have to think about long term. You remember at the onset, we talked about starting that practice and then having that exit strategy. This is part of it. Not even having a client or getting your first client, you're now on the hook for 7 years because you at least will have some connection with that person for 7 years. So think wisely before you begin a business. There is nothing wrong with thinking about it and then not executing it, or starting it and then ending it quickly. Just know that there are obligations that it is going to extend past your business. You decide to end the business, you decide to retire, whatever it may be, these files and these records are going to, I don't want to say haunt you, but they are going to be a lasting memory of this business. So keep that in mind. Okay. So that's the basic idea of things that are big, broad pictures about starting a business. Now, I'll pause here real quick because we're at a good starting spot, or I guess stopping spot, before we go into the next category. And I wanted to see if Anne, if there was any lingering questions that any of the members may have out there that I can answer.
Yes, Luke, we actually have a lot of questions. I'm trying to get them right now. So let me just go through a few for you, if you can help answer these. Okay. In California, are we required to be a sole proprietorship? Can an individual LMFT in a private practice be a C corporation?
So good questions. So are you obligated to be a sole proprietorship? No, you're not obligated to be a sole proprietorship. You can either be a sole proprietor, a sole proprietor, a general partnership, or a professional corporation. Now, as far as being a C corporation, generally a C or an S designation is based upon the IRS only. So you would establish a professional corporation because you would be performing professional services, and then you would elect to either be a S or a C corporation. I will cover that a little bit more as we progress, just because it is a bit complicated in that area. Truthfully, and I'll just kind of give a spoiler, it's better to be an S corporation, but we'll go over that as to why next, actually.
Thanks, Luke. And you also mentioned, there's so many documents and there's so many different legalities here. Where can attendees find an attorney, or what kind of attorney would you recommend to help our members with their documents?
Yeah, so two things with that. I will say that this presentation will hopefully cover a lot. As we progress, I will show you the actual forms that you need at the federal, state, local level. So this presentation may serve as a good starting spot. I will cover how complicated it is. So that was probably why an attorney would be helpful. I would always recommend a business formation attorney, especially if you're establishing a business. If you have a business, an employment attorney would be one that would be helpful. And as far as where to find one, there are plenty of places to find one. I think the easiest route to do is to just make a phone call. Each county that everyone lives in, I think there's 56 or 58 counties in California, there is a local county bar association. So like the San Diego County Bar Association, the Los Angeles County Bar Association, each one of those bar association has an attorney referral line. So basically what you would do is you would call up and say, hey, I'm looking to start a marriage and family therapist business. I don't even know where to start. Can you help me? And they would say, sure, let me connect you with Mike Griffin and, whoever it may be. And they will provide you the contact information or the phone number, and then you can move forward and have an initial consultation with them.
Great, thanks, Luke. And just one more question. So we have a lot of our members who are telehealth providers now.
Yes.
And if they're working from home, so I have a question from Don here. If you are a telehealth and working from home, and payments are sent to your home in a county, but you have an address, an office address in another county, which is only for like insurance purposes, for example. Should you get your business license in your home city or in the city where your office address is located?
So it's based upon where you're performing services. So if you're actually performing services at your home address, that is where you likely will need your business license or your business tax certificate.
Great. Thanks,
Okay.
Luke. I'm going to go through all the other questions on Q&A.
Okay, yeah, ask away. Okay, so let's go through selecting and naming a business, okay? This is kind of the exciting piece. So choosing the right business structure is a bit complicated, and it depends upon your needs. The more legal protections you have, the more that it's going to cost you. So sole proprietorship, very easy to set up, not a lot of legal protections. Professional corporation, it has quite a few different legal protections, but it's also going to cost you. As I mentioned earlier, there was generally a question about can you have an LLC? And there may be some individuals out there that have LLCs. I would maybe, if you do have an LLC and you are providing professional services underneath that LLC, to maybe speak to an attorney about this, because there could be a potential issue. This is directly from the California Secretary of State's website. A California limited liability company may not provide professional services in California. Professional services are defined as any type of professional services that may be lawfully rendered pursuant to a license. So as a licensed LMFT, you are providing professional services. A business that is an LLC is not able to provide professional services. Hence the reason why you have three choices: a sole proprietor, a professional corporation, or a general partnership. So I'm gonna make sure we make that clear. I cannot tell you how many people call up and say, hey, I'm looking to start an LLC. No. Okay, so let's talk about what you can do, and that is a sole proprietorship. The law recognizes one principal as being a sole proprietor if they have demonstrated an intent to carry on a business as a owner of a business for profit. I can't read today, apologize. So how do you actually start a sole proprietorship? Well, you have an idea and you say, I want to start a business. Poof, you have a sole proprietorship. It is that easy in California. There are no formal legal documents. So it is just simply you have a desire to start a business and you are there. You still need to obtain a business license. So that may be technically considered a formal legal document in the sense that you may need to do that. But as far as any additional documentation, there's really not. You don't have to file any documents with the Secretary of State, which is nice, unlike the other business structures where you may. Now, as far as taxation of a sole proprietorship, that is where, again, as we talked about earlier with the distinctions between the bank accounts, there is no separation between yourself and your business. So you are one and the same. As such, a sole proprietor is not subject to corporate income tax, and no tax return is filed on behalf of the business. Now, you will still file your own taxes as a sole proprietor, but you don't have to file a specific business tax for your sole proprietorship, which makes it extremely nice. That is where I think people get really hung up and they get really distracted and they just go, I don't want to deal with taxes and setting up the business, and I don't want to mess up, and they get scared. If you're looking to start a business that has as little as that as possible, that is going to be a sole proprietorship. Now, as I said, the easier it is to file, the less protections you have. And that is extremely true with sole proprietors. The chief drawback to this form of entity is a complete lack of protection of the principal's personal assets for unpaid debts and liabilities of the business. So what does that actually mean? I have this handy dandy chart, but let's talk about it in a basic sense. So imagine that you're a therapist and you have a client who sues you for malpractice. And for some reason, you ignored my presentation and you didn't get malpractice insurance. Okay. If you did, malpractice will hopefully help you. If you don't have malpractice insurance, and let's say you lose the case and it's $10,000, guess what? That $10,000 is going to come either from your business account that you've set up, hopefully, or your personal account. So that is where this is really a big drawback of this form of business, because there's really no separation between the two. Both the bank accounts are basically one and the same. So besides an accounting, that's why I said not a lot of difference between the two. So that is where the largest risk is with regards to sole proprietorship. Now, if that scares you, which it should, to be honest with you, then you may want to look at establishing a professional corporation. We'll get to that in just a moment. So, excuse me. So the next section that I want to go over is naming a sole proprietorship. So what are appropriate names for a sole proprietorship? Well, the law is pretty open-ended in this area, which is nice, because I'm sure everybody's heard of all of these specific rules and regulations with regards to naming. It's a lot more open with regards to sole proprietorships. The only general rule that you have is that it does need to include your surname, okay? If it does not contain your surname, then you are required to obtain a fictitious business name. I'll break that down. So imagine that I want to start an orange juice company. I am obsessed with orange juice. And imagine that you're starting a sole proprietorship. Well, what do I name that business? Well, Luke Martin Fresh Orange Juice. The end. Nice and easy. Simple. That would be perfectly fine. And the reason being is because my surname or my last name, Martin, is in the actual business name. Because of that, there's no issue with it. If however, I wanted to call it Fresh Orange Juice, Amazing Orange Juice, Crazy Orange Juice, Cool Orange Juice, first of all, that would be a horrible name. But second, if I did decide to name it that, it would be potentially problematic because my last name, my surname, is not in there. The reason why they have this requirement is actually for lawsuits, okay? So if I have my name in the actual business name, my surname in my business name, it is easy to identify who to sue. Since there's no formal legal documents with the actual Secretary of State, who do I sue if I'm injured by Luke Martin Fresh Orange Juice? Or who do I sue from Fresh Orange Juice, Amazing, Crazy, Awesome Orange Juice? Okay, you would have no idea, which is why the state of California and the code requires you to have your surname in it. Now, if you do not have your surname in it, the requirement would be for you to obtain a fictitious business name or a DBA. And that is filed with the county where the principal place of business is located. This is what it looks like in excuse me, this is what it looks like in San Diego. So it is essentially a form. You will provide, the fictitious business name, where it's located, the registration's information as to who owns it. Again, the reason for this is because who do I sue in this situation? I have no idea who I would sue unless there is something out there where I have basic information as to who these individuals are. This would allow you to, if you are a consumer who was injured by fresh orange juice, amazing orange juice, awesome orange juice, to be able to find who owns that. I can at least look up the fictitious business name and have that information provided to me and be able to potentially begin a lawsuit. So additional requirements if utilizing a fictitious business name. So marriage and family therapists who own a sole proprietorship may use fictitious business names so long as the name is not false, misleading, or deceptive. So that is kind of the catch-all here. So while you are having a lot more of an opportunity to name your business Adventure Therapy, it does pose a potential risk if you use a name that is inappropriate. Let's say Dr. Therapist. If you use the name Dr. Therapist and you only have an MA and you don't have a doctorate, or you're not a doctor, guess what? That's probably false, misleading, or deceptive. And that does, allow the BBS to kind of swoop in. So make sure in that sense that even though you have the flexibility and the freedom to be able to name your business as you like, make sure that you do so in a sense where it is at least reasonable, I think is the best way to state that. And then finally, the last requirement that you have to take into consideration is that if this is a private practice, you are required to provide the name and the license of the owner. And that is found in Business and Professions Code 4980.46. We'll talk about that with all of the business structures. That is usually done in the informed consent of an individual. So, if you have an existing business, make sure that that information is included in there in the informed consent already. If you are establishing a business, make sure that your information, your name and license of the owner is included in some sort of document that is obtainable by the client. Okay. So let's go over specific examples just to make sure that we understand this. So Brad is an LMFT who opens a sole proprietorship after getting his license. He names his business Be Radical Therapy Services. So the problem with this is that unfortunately, Be Radical Therapy Services does not contain Brad's surname. So this would not be appropriate. If, however, Brad names his business Be Radical Muldrow, which is his last name, Therapy Services, then that actually would be an appropriate name for him. Now, let's play out this scenario. Brad Muldrow is an LMFT who opens a sole proprietorship after getting his license. He hires 2 employees, Luke and Kristen. Brad names his business Be Radical Therapy Services. He obtains a fictitious business name. Kristen sees a client and asks the client to sign an informed consent. Kristen signs as the treating clinician and includes her license. Brad's name and license is missing. Well, in this scenario, it's problematic. While Brad is the owner, he does not actually have his last name in there. He does obtain a fictitious business name, which allows him to be able to call himself Be Radical Therapy Services. However, Brad, as the owner of that business, is unfortunately missing his license information in the informed consent. Because of that, it is problematic. And I want to circle back to this because I probably should explain this, because this is a common misconception. If you are a sole proprietorship, that means that there is one owner. That does not mean that there can only be one person working there. There can be multiple individuals working there as employees. So a sole proprietorship can have employees. It is not a one-person show. Okay, so there is the option to have multiple individuals working there as a sole proprietorship. So I want to make sure I clarify that and hopefully save a question for those out there. And then finally, let's go over this last scenario, which is the best scenario because it actually meets all the legal requirements. So Brad is an LMFT who opens a sole proprietorship after getting his license. He hires 2 employees, Luke and Kristen. Brad names his business Be Radical Therapy Services. He obtains a fictitious business name. Kristen sees a client and gets the client to sign the informed consent. Kristen's information is in the informed consent, and Brad's name and license information is also included in the informed consent. Perfect, Brad. You did a great job with that one. So that is essentially what you would need to have in order to be able to have a sole proprietorship. Okay. For those that are interested or more math oriented, 1 + 1 + 1 = 3. So that is how this looks. So if you are interested in learning more about that, you can take a look at that at your own leisure. Okay, that's a sole proprietorship. What about a general partnership? So a general partnership essentially works in a similar way to a sole proprietorship. The only difference between the two really is that there are 2 individuals who own the business rather than just one, okay? So how do you start a general partnership? Well, again, there are no required legal documents, okay? This is the default entity if there's more than one individual. So imagine that you are just goofing around with a colleague and providing services randomly, willy-nilly. Unfortunately, if something does go awry, this is the business structure that the law would say that you have. You would have a general partnership. Now, the one thing with the general partnership, which I think is really important to consider, is that you need, or I guess technically you don't need it, but you should obtain a partnership agreement. You can create one fairly simple. There are plenty of templates out there to be able to set that up. The one thing that you must do with any partnership agreement is talk about profits and losses, okay? And as well as termination of a relationship. If no partnership agreement, it is defaulted to 50-50, but you can create a partnership agreement that is 90-10, 70-30, 85-15. Math is early is difficult. So you can do whatever you want with regards to that. And as long as both parties sign and agree to it, then you do have the ability to establish that as the gold standard for your general partnership. You do have the option of registering with the Secretary of State. This is something that is new. Sole proprietors don't have this option. General partnerships have the ability to do so. They can file a statement of partnership authority. It is not a legal requirement to do, so it is something that if you would like to do, great. If not, you're not going to go to jail. Okay. Now, taxation is a little bit different with regards to as compared to a sole proprietorship. If you are establishing a general partnership, income and losses of the partnership flow onto and have to be reported on the individual partner's personal income tax. In California, the partnership is obliged to file a partnership return and a statement on their individual profit for their partnership. So if you are, again, scary numbers, probably set up a sole proprietorship if you're trying to avoid numbers. General partnership, it gets a little bit messy because you do have to report your partnership's return as well as do your own taxes, which is scary enough. So that is something that is a little bit different. These are the forms that you would have to fill out. It is the California Form 565 or the California Schedule K1. If you are using TurboTax or TurboTax or H&R Block, there may be, these are the forms that you answer the questions and then they fill out and then you would print and mail in. Okay, so not as scary because there are software and platforms out there to be able to help you, but these are the forms that they would be filling out. Now, the scariest part, and this is something that I will say is a bit scary with general partnerships, is that General partnerships are jointly and severally liable for obligations of the partnerships. And I know that's way over a lot of people's heads, and that's okay. Let me break it down for you. So imagine, and I'll actually, you know what, I'll just read this example because it does a good job. Mike and Kathy start an LMFT practice as general partners. Mike is a negligent LMFT and intentionally ignores a client in crisis. Bad. The end result is the client dies by suicide. The family of the decedent sues the partnership for $1 million for gross negligence. The court agrees that $1 million is appropriate. Due to being in a partnership, both Mike and Kathy are sued simultaneously, even though Kathy did nothing wrong. Sorry, Kathy. Mike is broke, but Kathy does have $1 million in the bank account. Kathy would be responsible for paying the full $1 million. Okay. Kathy would be eligible for reimbursement for Mike for $500,000, but that may be impossible considering that Mike is broke. So really, 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 really consider if a general partnership is a good idea just because of this alone. If you are terrified about lawsuits, you have to make sure that you trust the individual that you are getting into a partnership with immensely. Or you can be the pro person and then you'd be a little bit easier here, but let's not do that. So in that situation, it's really important that in a general partnership that you take into consideration your financial obligations here and also the financials of the partner, because ultimately at the end of the day, you two are tied together. And, you know, if something happens to one because of one partner, the other partner may be on the hook, which is potentially problematic for a lot of individuals. Okay. Naming a general partnership. Okay. With regards to naming a general partnership, the rules are pretty similar to that of a sole proprietorship. A partnership that will use a name that does not include the surname of each general partner, or a name that suggests the existence of additional owners, such as company and company and sons and associates, brothers, will likely require a fictitious business name. So, you know, if there are more than one owner, which of course there will be in a general partnership, both names or however many partners that you have, because you can have 3 or 4 partners, would need to be included in the name unless a fictitious business name exists. This is, again, the fictitious business name form in case you're in San Diego and curious what it looks like, but this form is pretty synonymous with what it would look like throughout. So there is that. Additional requirements if utilizing a fictitious business name. We've already gone over this with sole proprietors. If you are starting a general partnership, you want to make sure that your name is not false, misleading, or deceptive, and that all owners' names appear to be provided to the individual clients. So, you know, most likely put that in your informed consent. Here's some examples. Sarah and Mike, both licensed LMFTs, want to open a practice together. They run a space and begin working together. They jointly name their business Baby Yoda Fan Club. This unfortunately would not work as a general partnership because Baby Yoda is not Mike and Sarah's last name as much as they want it to be. Sarah and Mike, both licensed LMFTs, want to open a practice together. They run a space and begin working together. They jointly name their business Jasper and Griffin's Baby Yoda Fan Club Therapy. In that situation, because Sarah's last name is Jasper and Mike's last name is Griffin, that would actually be perfectly fine, although a very silly name. Let's look at this one now. Sarah and Mike, both licensed LMFTs, want to open a practice together. They run a space. They jointly name their business Jasper and Griffin's Baby Yoda Fan Club Therapy. They obtain a fictitious business name to utilize just Baby Yoda Fan Club Therapy. Sarah sees a client and asks the client to sign the uninformed consent. Sarah signs as the treating clinician and makes her license known. The problem with that is just because one partner makes it known, Mike also has to make it known as well in order for a general partnership to be appropriate. And because Mike's name and license information is missing, this would actually fall below the standard. And then finally, as I'm sure you can imagine, the grand scenario where everything works out. Sarah and Mike, both LMFTs, open a space, they begin working, they create Baby Yoda Fan Club Therapy with a fictitious business name. Sarah begins to see a client. Sarah provides her full name and her license. Mike does the same. In that scenario, you are good to go. Okay. And here, for those that are more visually inclined, this is what this would look like as well. Okay. Now, finally, let's go over professional corporations, and that is the big one. So a corporation is a fictitious legal entity that exists as an independent person separate from its principals, which basically means that you are here, your business is here. So there is a clear separation between the two. Unlike a sole proprietorship and potentially a general partnership where everything is combined, this one is clear separation between the two, okay? So how do you start a professional corporation? It's complicated. I am not going to sugarcoat it. It is complicated to start a professional corporation. There are ways to make it easier for you. There are companies out there that will set up a business. There are templates out there that you fill out, you put in your information. LegalZoom, I'm sure there's like I can't remember what it is. It's LegalZoom is one of them. Essentially what they do is they basically have a template, you put in the information, and then they generate the legal documents that you need. That makes life easier. You don't have to use them. I'm not recommending them by any means. If you do need assistance with this, this is where that business formation attorney would come into play. There are multiple legal documents that must be established and provided to the California Secretary of State, including the Articles of Organization, the corporate bylaws, and the Statement of Information. What is really critical to know is that if for some reason something is wrong with this corporation, this filing, unfortunately, depending upon the number of owners, it will default back to either a sole proprietorship or a general partnership. So hopefully you were paying attention. I know some of you were like, I don't care about a sole proprietor. I don't care about a general partnership. I only care about a professional corporation, which makes sense. However, if you already have a professional corporation or you're establishing a professional corporation and something goes wrong, you need to know what your legal protections are, hence the reason why we went over sole proprietorship and general partnership. So keep that in mind. If you tuned me out, fair enough. You have this presentation, just go back just so that way you know the potential issues. Okay, taxation of a professional corporation is complicated, okay? No ifs, ands, or buts about it. There are a lot of moving pieces with regards to a corporation, as well as taxes, because again, no different than you and your own personal taxes, your business has its own personal taxes as well. The first thing that needs to be considered when you are establishing a professional corporation is what designation you are going to make. So are you going to make a C corporation or a S corporation? There are two different types. A C corporation is a corporation that is generally taxed on their income, and the owners are taxed on these earnings when distributed. So basically, you get a check for $500, you are taxed on that $500. So let's say $450 goes into your bank account, and then you decide to pay yourself $250 out of that, it's taxed again. So C corporations are generally taxed twice, okay? S corporations are generally taxed on the income, and shareholders are taxed on their share of S corporations' taxable income, whether payments are distributed or not. S corporations are generally taxed once, okay? So to qualify for an S corporation status, the corporation must meet the following and fill out the IRS Form 2553. They have to be a domestic corporation, have no more than 100 shareholders, have only one class of stock, and not be an ineligible corporation. So not everyone qualifies to be an S corporation. So again, a lot of individuals, especially in this field, will meet the requirements. So that's the good news here. But if this is something that is already above your head, again, this is where a tax attorney or that business formation, CPAs, public accountants, they also do this type of work. So that may be someone that you would also want to speak with as well. Now, that's at the federal level. At the state level, you now are going to be introduced to the Franchise Tax Board, dreaded Franchise Tax Board. If you've never dealt with them, great. If you have, you know why there's a frustration. Let's say your business makes $0, but you've established that business. Too bad, so sad. You now have to pay a minimum of $800 to the Franchise Tax Board. You got to spend money to make money. So be careful, okay, when you are establishing a business, and make sure you know the consequences. If you are wanting to establish this business and you're debating between a sole proprietorship and a professional corporation, this is something that you need to consider. It is going to cost you quite a bit of money to be able to establish a professional corporation. And you are also going to have to pay at least $800 for the Franchise Tax Board, which, begins to add up, even if you make $0. So that is why you always need to have that exit strategy. And that is why you really need to plan if a business is appropriate or not. Because if you go through the motions and then all of a sudden stop after the business is created and just saying, there's a better opportunity, you're still on the hook for $800. And then you still have to let them know that you're dissolving your business. So that's where it gets complicated. Now, the one good thing about it being complicated and it being costly is liability. So when someone sues, they are going to sue the business, and the business is going to likely be on the hook. Now, they may try to sue you personally. That may be something that they do, but generally there are legal strategies and ways to be able to protect yourself in that sense. They will likely sue the organization, and the organization, remember, separate bank accounts, it will come out of the bank account of that organization or of that professional corporation rather than your personal bank account, which is great. Now, there are loopholes to that. We're attorneys, so we understand that individuals may try to be a little bit interesting with the numbers. And so we've created this concept called piercing the corporate veil, which is essentially the idea that, if you do something a little shady, then, there may be ways for us to say, well, you might have your bank account over here, but we still want it. So that's why I really think it's really important to make sure that you know what you're getting into with your professional corporation. Because establishing a professional corporation, getting into trouble may not solve all of your problems. You may not be able to rely exclusively on that professional corporation. If you don't put money in there, you commit fraud, you don't follow corporate formalities, they can still go after your personal accounts, which is problematic. Okay, so there's a lot that goes into establishing a professional corporation. If you do it right, you are going to have legal protection. If you don't do it correctly, then you're still stuck as if you are a sole proprietor or a general partnership. So keep that in mind. Finally, naming a professional corporation. This is where a lot of individuals struggle, okay? So starting with a sole proprietorship and a professional corporation, the main thing that you have to take into consideration is your surname. With a professional corporation, there's more to it than that, okay? That is because of Business and Professions Code 4987.7, okay? It basically says that a marriage and family therapist professional corporation must contain one or more of the following words in its name: marriage, family, and child, together with one or more of the following words: counseling, counselor, therapy, therapist, and wording or abbreviation denoting corporate existence. So if I want to call myself Luke Martin Marriage and Family Therapist, Inc., I am perfectly fine. If I want to call myself Adventure Therapy, that's a problem, okay? And the reason why is because it doesn't include these words. The way that I always approach it is that you need a word from category A and a word from category B. Category A words, marriage, family, child. Category B words, counseling, counselor, therapy, therapist. So if you have one word from category A and one word from category B, then you're going to be okay. If not, there's other things. So with a professional corporation, again, there are more filing documents and things that you have to go through the process. It is a little bit, it is more difficult to be able to select a name. In order to determine if a name is available, you may submit to the Secretary of State a name reservation request form, which allows the name to be secured for 60 days. So if you're in the process of thinking about different names, and you're worried because there's this new form of therapy out there and you want to get on it right away, or you are afraid that a colleague is going to steal your name for whatever reason, in that sense, you do have the ability to secure that name right away. It's not something that's very common, especially in this profession, just because, there's not a lot of changes happening. But, as psychotherapy develops, there may be something new. So even if you're approaching this later down the road, just know that you do have the ability to secure that for 60 days if that comes to play. As we talked about, not only do you have to include the category A and category B words, but you must also include a designation such as professional corporation, corporation, incorporated, INC, PC at the end of your name to be able to signify that it is a professional corporation or a corporation in general. And finally, a corporation doing business under a name not stated in the Articles of Incorporation or Articles of Organization filed with the Secretary of State will require a fictitious business name. Okay, so this occurs when you have a business such as, let's just say, CAMFT, California Association of Marriage and Family Therapists. We always use the acronym CAMFT, CAMFT. If for whatever reason in our articles of organization or our articles of incorporation, we don't use the moniker CAMFT in there, we either A, have to change the articles of incorporation or articles of organization, or obtain a fictitious business name. So a lot of moving pieces here, a lot of things to take into consideration, just naming a business, okay? If this is well above your head, if you need more information, fear not. The California Secretary of State does have an FAQ, so that way you can go ahead and look at it. I will say that this is the #1 reason why businesses get kicked back from the Secretary of State, is that they don't meet naming requirements, which is why I'm going over it so in depth. Okay. In addition, we've already talked about this throughout, if you are using a name that is false, misleading, or deceptive, you will need to make sure that you obtain a fictitious business. You cannot use a fictitious business name that is false, misleading, or deceptive. And you are also required to name and provide the license of the owners of the professional corporation as well. So let's go over these examples just to make sure that we understand it. Anne and Dan, both licensed LMFTs, want to open a practice together. They hire an attorney to set up their professional corporation. They decide to name their business Fabulous Child. Unfortunately, that is missing the category B words, therapy, therapist, counselor, counseling, so that does not meet the requirements. What if Anne and Dan both want to set up that practice and they decide to name it Fabulous Child Therapy, which has both a category A and a category B word? It still does not work because it does not have the Inc. or the professional corporation. Anne and Dan want to start a business and they call it Fabulous Child Therapy Inc. Good job, Anne and Dan. That will work out perfect. Okay. Now let's do this. Anne and Dan want to start an LMFT practice. They decide to name their business Fabulous Marriage Therapy, Inc., realizing they're not trendy enough. Anne and Dan begin to advertise as Fab Child Therapy without changing their articles of incorporation. Unfortunately, Fab Child Therapy will not work. They will need to obtain a fictitious business name, or they will need to amend their articles of incorporation or articles of organization. Finally, Anne and Dan, they start a business. They call it Fabulous Marriage Therapy, Inc. Realizing no one likes their name, they begin to advertise as Fab Child Therapy without changing their articles of incorporation, but they do get a fictitious business name. Good job. That is a-okay. Changing the articles of incorporation and articles of organization is a bit complicated, which is why the fictitious business name is the preferred method. Otherwise, you will have to submit that back to the Secretary of State, which can be cumbersome to do. That's it with regards to selecting a business. That is it with naming a business. As I mentioned earlier, CAMFT has a lot of resources on this. Specifically, we have articles selecting and forming the right private practice entity, naming private practices. All of that information is in the CAMFT articles. Just log on to the CAMFT website. We will happily guide you to these articles. If you call in, we can potentially answer any questions that you may have on this topic. With that in mind, Anne, do we have any questions that are lingering and out there that will give me a pause for a moment to drink?
Yes, we do. We've gotten some really great questions. Okay, I'm going to go through the ones I've marked for live. Is it possible to start an S Corp with a therapist located in a different state? If so, can it be done in either state?
So that's a bit complicated. There can be multiple owners in different states. There are legal requirements for ownership as to who can own a business. So I would be a bit concerned about that because, you know, if they're licensed underneath a different license and you're trying to establish that business, then there could be potential issues. I do think that that would be something where it is feasible, but I would definitely talk to an attorney. And I unfortunately think it's going to be quite expensive because you're going to need an attorney who's going to be familiar with both California law and, let's say, Oregon. It may be advisable to establish a business here in California, or it may be advisable to start a business in Oregon. It just depends upon the situation. There's also tax implications. So I definitely think that's a very, very complicated question. I don't have a sufficient or good answer for you just because you would have to analyze what state it is, what license it is, but it is potentially feasible. Talk to an attorney about that specifically.
Great, thanks, Luke. Okay, in regards to the one of your vignettes on the general partnership liability, wouldn't the malpractice insurance protect? I think it was the vignette with Mike and Kathy.
Sure.
So how would their malpractice insurance cover them in that situation? Okay,
good question. I was hoping to glaze over that, but yes, they could, except I think I put in the vignette, and you know, I'm sure there may be somebody that can go back, gross negligence, which is like above and beyond. So in certain situations where there's gross negligence, and a malpractice insurance will not cover you. So I think I wrote gross negligence on purpose just to kind of avoid that issue. But yes, to answer your question sufficiently, yes. If it is just general negligence, then yes. If it is gross negligence or above what is covered by your policy, then you may be, even with insurance, on the hook.
Right, there are some exclusions in their policy, so something that they have to take a look at
Yes.
in regards to their malpractice. Okay, thanks, Luke. And then one more question. When would you suggest considering trademarking your business name or like your DBA?
Yeah, that's a good question. There's not a specific time. I think if you have an excellent name, such as like Los Angeles Therapy, you know, it's probably something that you want to do right away. I have no doubt that that's already taken. But you want to make sure that you protect your brand as soon as potentially possible. And when your brand has a value, that is when you are going to want to trademark, copyright, anything that you have to provide legal protections for yourself. So if your name is, Luke Martin Therapy, and, there's nothing significant or important about Luke Martin Therapy, then I wouldn't advise it. However, if you become a celebrity or you're a famous therapist for whatever reason, and you are, generating business and your name holds value, absolutely, then I would highly recommend it.
Great. Thanks, Luke.
Yeah. Okay, well, we are a little off on time. We are going to go to break at 10:30, so we have a few more minutes. So I will go ahead and just kind of give us a large overview to kind of fill the time before we go on our break. And that is our next step in starting a business, which is hiring an employee, okay? If you thought establishing a business was complicated, just you wait until you have to hire an employee. That's where it gets to be extremely complicated, which is why you really want to plan this out. What I did in this section of the presentation is I try to break it down as best I could for you to be able to kind of figure out the federal requirements, the state requirements, the local requirements, the cities that you're in, and then your company's requirements. Because unfortunately, the way that the law is set up is that you have to comply with all 4 of these in order to be able to hire a person lawfully. It's complicated. There is really, really specific laws in employment law. And as I mentioned earlier on the onset, California specifically is very employee-centered, not employer-centered, which is why it is extremely critical to make sure that you are well aware of all of the legal requirements. Now, what I will tell you is that this part of the presentation will go over every single thing that I believe that you need to be made aware of. There are other things that may be unique or specific to your business. If so, I'm going to default to, talk to a specific employment attorney in this area. I always look at this section as a kind of a choose your own adventure, or if you are, I'm obsessed with Nashville hot chicken right now. So, if you are one of those persons who likes it not spicy, then just keep with your company responsibilities. If you like it mild, then, local requirements, maybe you can handle those. Medium, state requirements, you're spicy. And then if you think that you can do everything, I mean, you're at the extreme level. It is very spicy, it's very hot. And then, if you think that you can handle it, then you can probably handle the federal requirements. That's kind of the threshold that I would look at, the spice level with regards to the legal requirements. What I will say also to this is that, when we're going over this presentation and this part of the presentation, if you believe that, you thought you could handle the medium and now you can't, that's okay. Okay, that is perfectly fine. There is nothing wrong with that. The reason why I say that is because there are plenty of consultants out there. There are employment attorneys, CPAs, human resource specialists that are able to assist and guide you in that area. So that way you have a better opportunity to be able to make sure you meet these requirements. And if you think about it logically, I mean, an employment attorney, a CPA, a human resource specialist, these are individuals who specialize in this area. So it is something that they went to school for. So it is going to be complicated. It is not something that an average person is going to know about. I mean, knowing about shift differentials on the top of your head is not something that a general attorney will know about, okay? But depending upon your business, that may be something that you have to meet, okay? So there are organizations that can help. If you are a CAMFT member, we do have an affinity partner, ADP. ADP is out there. They are able to assist you in this area. They may be able to even provide you discounts because of your CAMFT membership. We do have a phone number as well as information for an email as to who to contact. That information is also on the CAMFT website. So again, if you need assistance with payroll, HR, benefits, anything like that, that is a person that you would want to, an organization that you would want to speak with. Okay, so things to do on the federal level. Okay, so remember, this is the spicy, because this is going to be complicated stuff, because you're going to be dealing with the IRS, you're going to be dealing with the soon to be franchise tax board more. At the federal level, you're going to need to apply for an EIN. You're going to have an employee fill out the IRS W-4. You're going to have an employee fill out the I-9. You're going to have to withhold a portion of each employee's income and deposit into the IRS. You're going to have to make Social Security and Medicare tax payments to the IRS. You're going to have each employer must complete the W-2, the wage and tax statements. You have to report wages, tips, and other compensation. You have to keep these records for 4 years, and you have to consider the federal laws as well. So there's going to be a lot, okay? And so I am just going to tease this for you right now. But when we come back from break, we are going to go over these federal requirements. We are going to talk about what it actually means to deposit money into the IRS. We're then going to be talking about the franchise tax board, where you're going to have to deposit money there, unemployment insurance, disability insurance. There is a lot that goes into it. So as I mentioned earlier, an EIN number is generally something that a business would want to obtain. As a business, you have two options, either providing your Social Security number or your EIN. Applying for an EIN is relatively easy to do. It's something that you're going to need for tax purposes. It's something that you're going to need for reporting things to the IRS. It's something that you're likely going to need for insurance. Obtaining an EIN is something that you just do on the IRS website. It should be relatively simple and something that you can do yourself. As far as additional forms that you need at the federal level, the first thing that should come to mind, and we all should be familiar with, is the W-4 form. This is a form that is a requirement for each and every employee to fill out. This goes over how many allowances they are claiming for tax purposes, so that way you can withhold the correct amount. You don't have to file this form with the IRS, but it is something that you must hold on to, because this is what's going to tell you how much money to withhold from your employees' paychecks. The second form that you really need to consider in making sure that you have when you're establishing a business and looking at it from the federal level is the I-9 employment eligibility verification form. So there are legal requirements that only certain individuals are eligible to be able to perform services or be hired as employees in the United States, as well as in California specifically. So this is the I-9 form. This form should be relatively similar to what a lot of individuals have already seen. This is the one where you have to show your passport, your driver's license, your Social Security number. So this is that form. It does need to be filled out, and it does need to be stored and kept. For those that are wanting more information about the federal level and more information about storing records, how much taxes to withhold, anything along those lines, this Publication 15 on the IRS website is where you are going to go, okay? It's Publication 15, which is kind of a strange name. It's the Employer Tax Guide. It does have some really great information as to how to figure out what to withhold for Social Security, what to withhold for Medicare, what to withhold just for federal tax purposes. So this is going to be your go-to document with regards to any questions. So if you're, again, at that spice level where you are extremely hot and you are a go-getter and want to learn about this, and you're wanting to know where to start, I would look at Publication 15. Okay. There are 3 different considerations at the federal level for withholding funds for employees' paychecks at the federal level. There is federal income tax, there's Social Security, and there is Medicare. Employers generally must withhold federal income tax from employees' wages. There may be a few exceptions to the rules. So if you believe that you have a unique situation, reach out to an employment attorney or check that publication 15. You must then, once you withhold it, you also must deposit your withholdings, and we'll go over where to deposit them in just a second. And then at the Social Security and Medicare level, an employer generally must withhold part of Social Security and Medicare taxes from employees' wages, and the employer additionally pays a matching amount. As far as what that range is, that is something that you are going to have to look at, again, publication 15 as to the actual percentage. Most organizations, I'll be honest with you, have a payroll company that handles this themselves. They are familiar with it. So if you are wanting to handle this all on your own, cool, good job. Fingers crossed for you. It's complicated. So again, when we said you have to spend money to make money, this is kind of what we're talking about. So in order to be able to have any employees, you are also going to have to figure out a way to pay those employees. You're going to have to withhold their taxes at the federal level. You are also going to have to withhold their Social Security and Medicare. And you are also going to have to provide a matching amount. Quite complicated in this area. Okay. Next, you are going to have to deposit those funds. Okay. This is where it gets really fun, and you're going to have to become familiar with EFTPS. Okay. So in general, you must deposit federal income tax and Medicare and employee Social Security and Medicare taxes into the EFTPS system. It stands for Electronic Federal Tax Payment System, in case you're curious. There are 2 deposit schedules, monthly and semi-weekly. Before the beginning of each calendar year, you must determine which of the 2 deposit schedules you are required to use. You may want to look at publication 15 because it goes over forms that are going to be needed. If you fail to make timely deposits, you may be subject to failure to deposit penalty up to 15%. So again, this is complicated. This is why we have the HR. Again, this is the really, really high level stuff that's going to be complicated. I know looks like there's quite a few of you on this recording, and I'm sure this is going well over your head. Unless you are somebody who has worked in HR before, this may not be something you're familiar with. However, when you're starting a business and you're having employees, this is something that you're going to have to become really familiar with, or you're going to have to find an organization that is to be able to supplement. Okay. Reporting employment taxes. Generally, not only do you have to deposit the funds, but the IRS has to know what you're depositing and why. And there are 3 general forms that have to be filled out, depending upon your situation. It's Form 940, Form 941, and Form 944. Okay. Again, usually in these situations, this is something that no one ever deals with. Okay. There are companies out there. Again, these are for those go-getters, those people that like it spicy, who want to do this on your own. Keep this in mind as well. If you are starting an organization and you're wanting to hire your best friend for services, even if it's your best friend, you're still legally obligated to do this. So really take into consideration if you are wanting to file to have an employee. Next, excuse me, and you also must e-file all of these forms. So these are all something that, it's not something that you can do through paper. It's something that you have to e-file. Okay. Let's say that all that works out. Then the next thing that you have to do is you have to prepare and file a W-2. Okay. So essentially those 940s, 941, 944, all of those are collected. Those are all reviewed. And then at the end of the year, you have to file a W-2 for each employee. Okay. That W-2 is what you use and what they are going to use for tax purposes. So that is what you are going to need there. Now let's go here. Okay, so That is really a high level overview of what you're going to have at the federal level. You're going to have to be able to withhold taxes. You're going to have to be able to store funds. You are going to have to make payments yourself for your organization. You are then going to have to summarize that in a W-2, and then you're going to have to keep these for 4 years. So even if you don't see any clients during this period of time, but you have an employee, this business is going to follow you for 4 years. So there's a lot that goes in at the federal level. It's quite cumbersome because you're dealing with the IRS. It's very technical, and there's only so much that a person can really understand in this area, which is why a HR representative, a payroll company, ADP is really recommended just to be on the safe side. Okay. Federal laws to consider. Okay, so we're going to discuss in various parts of this presentation specific laws that are relevant. So federal law is basically something that all employees have to follow. Then it gets to be more specific at the state level, even more specific at the local level, and then you can even make it more specific at the company level. But the big overarching laws that you have to consider at the federal level that everyone has to comply with is the Fair Labor Standard Act, the OSHA, which is the Safety of Employees, and the Federal Medical Leave Act. So again, if you're looking to become familiarized in federal laws, which I'm sure everybody is smiling going, yes, I would love to learn more about federal laws because why not? I'm also a therapist and I have a million other projects. But if you are and you're that go-getter, then in addition to looking at publication 15, which is going to, if you need a read to go to sleep, that's it. You also may want to look at the Federal Labor Standard Act, OSHA, and then if you're looking for the trifecta of needing reading material to put you to sleep, the Family Medical Leave Act will do just that for you. Okay. And those are the baseline federal requirements. OSHA, FMLA, those are big ticket items. I just basically touched and ran with those. So if you do have individuals who are needing to comply with those, if you have individuals who are going on medical leave, if you have safety issues at your office, even if you don't have safety issues, that may be something that you need to become familiar with, just because it is something that you do have to comply with. All businesses must. Okay. Things to do on the state level. Okay. So on the state level, there is registering with the EDD, pay state payroll taxes. That includes unemployment insurance, which is the employer contribution, disability insurance, which is the employee contribution, workers' compensation insurance, onboarding paperwork and posters, California new hire reporting programs, and state laws. Again, there's a lot, okay? I cannot harp enough that this presentation is going to give you a laundry list of to-do projects, and don't feel obligated to understand everything in this presentation today. There is a lot of exceptions. There are a lot of specifics to your organization, but if nothing else about this presentation, I want you to become familiarized with these terms, or, to be honest with you, realize that they exist. I mean, California new hire reporting program, unless you've already established a business, you're probably not going to know about that, but it is a requirement. So let's go over this as quickly as I can touch and go. Okay. So EDD. So if you didn't like the IRS, you are not going to like EDD. EDD stands for the Employment Development Department with the state of California. It is one of the largest state departments. They handle quite a bit. They handle unemployment. They handle state disability. They handle audits and collects payroll taxes. They connect job seekers. They gather and publish information. So EDD does quite a bit for the state of California, and is something that is a large part of any California employer's life. Okay, so the good news is that EDD tries to make it as simple as possible. So this is something where if you are familiarized with EDD, then it's going to make your life way easier. They do a great job of providing how to get started with EDD, which is extremely easy. They even provide different handouts. So if you are a reader, they have this. If you are more of a flowchart person, then this is for you. So EDD does a very good job. I will say that they put out some really great resources to be able to assist and to be able to help you get started. Now, getting a hold of them by phone, a totally different avenue. Getting a hold of EDD is it's like pulling teeth. There's long waits. If you've ever had to deal with EDD and call them, it's pretty painful. So that's probably why they put out such great resources. Again, if you're unable to get a hold of EDD, your next best bet is to contact an employment attorney in this area. Okay. Unemployment insurance. Okay, so at the federal level, you have federal tax, you have Social Security, you have Medicare. At the state level, you have unemployment insurance. This was established as part of a national program. The unemployment insurance program provides temporary payments to individuals who are unemployed through no fault of their own. Okay, the unemployment program is funded through payroll taxes paid by the employer. Okay, employer. So again, these are things that you are going to have to pay as a new business owner. The unemployment rate schedule and amount of taxable wages are determined annually. So this can go up and this can go down. Okay, if you are starting a business, okay, and you have one employee and that employee makes $7,000 or more, you are going to have to pay 3.4% for the first 2 to 3 years for that employee. What does that mean? Okay, so if you have an employee that makes $50,000, you pay 3.4% taxes on the first $7,000 that they make. Okay, that's it per employee for the first 2 to 3 years. Now that 3.4 is an adjustable rate. So a lot of businesses out there are like, I have an employee that's on unemployment. They filed a claim with EDD. Are my rates going to go up? The answer is yes, they could. And this is where it's at, okay? Your rate is determined annually. When you start a new business, it's going to be at 3.4%. As the business grows, as you have more claims, it can go up. Okay, the maximum that you would have to pay for an employee is 6.2% in California. So you pay 6.2% of the first $7,000 that they make, which is $434 per employee per year is the max that you're going to have to pay for unemployment insurance. Okay, that's a lot to take in, but that is what the law requires you to do in this situation. The more that you have individuals on unemployment, that higher that percentage is going to be. 3.4 is the floor, 6.2 is the ceiling. So, you have no employees on unemployment, you're going to be hovering towards the floor. The more individuals you terminate, the more that they go into unemployment, the higher that you're going to actually get to the actual ceiling in that situation. Okay. And for those that are unaware, an unemployment insurance is what is a benefit for employees who are eligible who lose their position. There's a lot that goes into who can file for unemployment, who can't. I'm not going to touch on that. If you have individuals who are interested in that, then if we have individuals who are interested in that, please speak out to an employment attorney on that manner. Okay. State disability insurance. Okay. This is a deduction from the employee's wages. Okay. So that's a good thing for employers because that means that they don't have to pay. This is usually shown as CASDI on your pay stub. This means that each time an employee gets paid 1.2% of their wages, it goes to SDI. SDI taxes up to $128,000 per year. So if you have an employee that makes 150, they're only going to get taxed on 128. So that means that the maximum that an employee will pay for state disability is $1,539.58. Not that you need to know that. It's just, I would be curious too, how much money am I actually paying for this? And that's the amount that you're the most that you're going to be paying. Okay. Disability insurance provides a short-term wage replacement benefit to eligible employees. To be eligible, the employee should have a disability not related to their work. SDI defines disability as any mental or physical illness or injury which prevents you from performing your regular and customary services. As an employer, you don't pay California SDI. However, you do need to withhold and send employee contributions to EDD. Okay, so that's where your responsibility comes in. So with regards to unemployment, you're on the hook. State disability, your employees on the hook. As far as your responsibilities, you are responsible for paying both. As far as other considerations at the state level from a tax perspective, you are required to have an employee fill out a DE4 California payroll tax form. This form should be familiar for most individuals here who are California based. They are no different than the W-4 form. You're also obligated to do the DE4 California payroll. Those forms will ask how much money the employee would like to have withhold from the state tax purposes or state tax purposes. So federal taxes is IRS, state taxes is EDD. Okay. So as we talked about earlier, there are a lot of requirements and it is not easy. And this is essentially a list of required pamphlets to be given to an employee. Again, I'll go over them briefly, but I'm just going to touch and go. A lot of these are going to be on the EDD website for employers to be able to pull. So usually when you start a business and you hire an employee, you have to give them all of the federal forms that I mentioned. You have to give them the state forms that I've already mentioned. And then you also have to give them the pamphlets. Okay. So the required pamphlets at the state level are workers' compensation, time of hire information sheet, Wage Theft Prevention Act notice, the DFEH 185, which explains sexual harassment, DFEH 188, which covers the California Family Rights Act, DE 2515, which covers disability insurance, DE 2511, which is the paid family leave insurance. There's a rights of victims of domestic violence, sexual assault, and stalking information sheet, a statement that you have followed EEO standards of non-discrimination in hiring practices. Those are the requirements. This isn't a comprehensive list. This is just a general list of forms that need to be given. There may be additional forms that may need to be given depending upon your situation, your type of business that you're establishing. So this isn't comprehensive. This is a lot, but again, like I said earlier on the onset, this is going to be touch and go. These are things that you're going to have to familiarize yourself with at any given point. Or if you already have an established business and you are curious if you are giving the right documents or that you have the right documents, this is maybe something that you can use as a checklist for your own hiring intake paperwork. Usually this is covered by an HR representative, an employment attorney, and a payroll company. However, if you're doing this on your own, this is a good checklist to at least start. In addition to pamphlets, the little handouts that you give, there's already one that you should be familiar with, which is the therapist that, therapy doesn't include sex. I can't even think of the name of it on the top of my head, but that pamphlet, those are the documents that I'm talking about. These are pamphlets. Workplace posters are something different. These are the posters that usually go in common areas or break rooms for individuals. That is going to be the employee rights underneath the Fair Labor Standards Act, job safety, which is OSHA, the employee rights and responsibilities, the equal opportunity is the law, EEO poster. There are companies out there that will do this for you. Usually you work with one of those organizations and they will send you an annual poster that you need to be posted. It'll say 2022, 2023, 2024, and it'll give you the current laws and it will meet the requirements. I would highly recommend obtaining one of those. Again, it's another cost that's associated with hiring an employee, but it is well worth it. Okay, workers' compensation insurance. Okay, so we talked about previously malpractice insurance. We talked about general liability, slip and fall insurance. This is another insurance that you are likely going to have to obtain, okay, which is workers' compensation insurance. All California employers must provide workers' compensation benefits to their employees under labor code. If a business employs one or more employees, then it must satisfy the requirement of this law. Workers' compensation law covers only injuries or illnesses that are related to the employee's job, or in legalese, arising out of employment and occurring during the course of employment. Employers must purchase workers' compensation insurance from either a licensed insurance company or through the state compensation insurance fund. Employers may also have the option to self-insure for workers' compensation. I don't know why I put that in there. If you have $5 million, then you don't need to be looking at this presentation. You can, have somebody to set this up for you really easily. If you do have $5 million and you're listening to this presentation and you don't want to have workers' compensation insurance, perfectly fine. Kudos to you. You do have to make a security deposit, so you're not going to have $5 million for long. You'll have to put some of that in there, but all businesses really, truly do need workers' compensation insurance. Okay. Now, I touched this earlier, the California New Hire Reporting Program. Okay. So all California employers must report all of their new or rehired employees who work in California to the new employee registry within 20 days of the start of work date, which is the first day of work. Okay. You're required by law to report the following: the employer's California employer payroll tax account number, the federal employer identification number, business name, address, contact information, as well as the employee's first, middle, last name, social security, home address, start of the work date. Okay. So you're kind of thinking, okay, so I have to bring this person aboard. I have to make them fill out the paperwork. I already have to have IRS. I have to have EDD. And now I have to tell them that I have a new employee. Yes. Okay. Oof. It's a lot to say. I'm sure a lot of you are overwhelmed and saying this is a lot to do. Good. It is a lot to do. And it's good that you're having these feelings and you're processing them now, because it is better to process them during this 3-hour presentation than to have a new employee that starts on Monday and you have no idea what to do. Okay. So it's good that you're having these feelings. Feel free to refer to this presentation at any time. Okay. As far as why we do this, okay, the reason why we do this is because if there are any wage garnishments for back child support, if there is a lawsuit that was filed and this person owes money, then they have to be reported for this, so that way this organization can reach back out to you and they can work with your payroll company to withhold funds for, like I said, back child support. Okay, so there's a lot that goes in that EDD works with. So you have a lot of withholdings. California SDI, you have franchise tax board withholdings for state taxes. You have the IRS. So this is another one that is very rare. I will say that this isn't something that a lot of employers have to do with on a regular basis. However, you never know. Okay. And so you may hire an employee that does have a wage garnishment and that you have to comply with, and you have to garnish their wages. Okay. So we have the need to discuss state laws in general, okay? We are going to be talking about independent contractors in just a little bit, but no different than when we talked about OSHA and FMLA and Fair Standards and Labor Acts. There are employment laws that are specific to California. California does have some unique laws with regards to employment status, such as an employee, an independent contractor. So you are going to want to make sure that you are familiar with those laws. Another law that you are going to want to learn more about is the CalSavers Retirement Savings Program. This may be a program that even if you have a business, you may not be aware of. So, if that's you in this situation, you may want to pay close attention. This was created by state law to ensure all California workers can save for retirement through automatic payroll contributions facilitated from their workplace. If the employer already has a retirement plan, you're good. You don't have to pay attention. But if you are an employer who does not have a retirement plan, you do need to pay attention because the CalSaver plan may be something that you have to look into, okay? Eligible employers with 5 or more are required to participate immediately. Those that have 1 or more may be required to participate by December 31st, 2025. Exceptions apply for sole proprietors where they're the only employee is themselves. So what does this mean? Let's say that you're a business that has been around for 10 years and you have 3 employees, okay? Those employees do not have a retirement plan, okay? No problem. You are good until 2025. However, beginning in 2025, that is something that you're going to have to begin to think about. You are going to have to establish a retirement savings program for your individuals. That is something that you can do with a third party, whatever insurance, whatever retirement company you feel most comfortable with, Goldman Sachs, whoever it may be, or you have to look into the CalSavers plan. So that is something that is going to impact all businesses moving forward. It just depends upon the time frame as to when it goes into effect. If you are already having 5 or more employees and you have not, and you don't have a retirement plan, you are technically not in compliance with this. So that is something that you may need to be speaking with your payroll company or whoever is handling your situation. And if that's you, you need to be talking to yourself about this specific issue. Okay. So that is the state requirements, federal, state, and now we are at local requirements. Now, remember, we are talking about the spice levels again. Remember the really spicy, the medium. So those are we've dealt with the spicy, we've dealt with the medium. Now we're at the mild section. So these are the local requirements. These are things that you should feel more familiar with, but it is going to be unique to your business. So that is why when you hire an attorney or you deal with something, or you're dealing with your own, you have to look at all 4, unfortunately. I wish there was one place that I could refer you to that, look here and ta-da, that's it. That's the point of this presentation, is to kind of give you at least a place to start with, to either acknowledge that these exist or to kind of get an understanding as to where to look for further information. And this can't be exemplified more than with wages, okay? At the federal level, minimum wage, $7.25, okay? I can imagine any employer out there is like, I would love to pay $7.25 for minimum wage. That's going to save me quite a bit of money and it's going to help my profit. Unfortunately, again, federal is the floor and it's going to get higher and higher. If you are in California, the minimum wage is $15.50 an hour as of January 1st, 2023, okay? California sets that out as what minimum wage is, okay? However, and this is why we're talking about it at the local level, while the state of California says $15.50 is the minimum wage in California, the city of San Diego, and again, this is going to be very big depending upon your specific location, says the minimum wage rate is $16.30 as of January 1st, 2023. Okay. Reason why I show that Big difference, 725, 1630. Okay, it's off the screen. It's a high difference. So you are going to have to pay each of your employees at least minimum wage for every hour that they work in San Diego. Let's just imagine San Diego, it's going to be $16.30. Okay. There are a lot of individuals out there, and I'm sure there's probably questions popping up about, well, I do a 50-50 split, I do a 60-40 split. And so, they're well above 1630. Problem, okay? Minimum wage is based upon the hours that they work. If your employee is paid for 50-50, let's say 50-50, and, it takes them quite a few hours to be able to earn that $50. You have to calculate it by hours because you can still fall below the minimum wage. How does that work? Okay. Imagine an associate charges $100 per session, right? $100. There's a 50-50 split, which means that that individual is going to make $50. Okay. That associate is going to make $50. Great. $50 is above 1630. Now, the problem, though, is that 1630 is required for each hour that they work. What happens if that employee later down the road, because it's never when things are going good, it's always when things are going bad, decides to say, look, I didn't make minimum wage. Well, that onus is on the actual employer to prove that they did. Your response would be, look, they made $50. We're good. The employee can come back and say, well, yes, I did make $50, but it took me 1 hour to be able to do the therapeutic session, 1 hour to do the notes. I was required to attend supervision. I was required to take a training. I had to do 1 hour of additional research outside. Well, that's 5 hours, okay? So they made $50, but it took them 5 hours to be able to make that. That unfortunately falls below minimum wage, okay? That's a problem. When you fall below minimum wage, they can come back and they can file a complaint with you that they didn't make minimum wage. The onus is on the employer to prove that they did. The best way to combat that as an employer is to require your employees to fill out a time card. Ooh, I know you're going to hate it. Your employees are going to hate it, but you are going to love it when a lawsuit commences and you can pull out that time card and say, no, 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 no. For that week, they reported 2 hours, 1 hour for the therapeutic session, 1 hour for the notes. 2 hours, $25, I'm good. Otherwise, if they allege that they worked 5 hours and you have no way of supporting that they didn't, the onus is on you as the employer. You're on the hook. And so that would be in San Diego, 1630 times 5. And I'm sure somebody has a calculator out there. I think that's $80 and some change. I can't do the math. In that sense, you're responsible for that and the difference. So if they made 50, they should have made 80. You got to pay them $30. And then there's also penalties and fees for not paying them in advance. So at that $30 plus $20, it adds up quickly, and it's quite expensive. Okay. Another example of this is sick time. Okay, sick time is going to vary. Now, everyone needs to be made aware that in California, you are required to provide sick time. So even if you don't provide PTO or vacation, you are required to provide sick time. Now, there are alternatives. If you provide PTO, you may be able to get around this. So make sure you talk to an employment attorney. But let's just imagine that you're starting a business. You have no idea what you're doing. Federal sick time, there is none. Federal level, they say you get sick, they don't have to pay you. Okay. State of California says that any individual that has to be given at least 24 hours or 3 days off each year, including full-time, part-time, and temporary workers. Okay. So you have to give everybody at least 3 days every year. Now, there's ways to do that. You can give them the full 3 days right at the onset, or you can give them like a percentage. So, for every 30 hours they work, they get 1.25 hours, whatever it may be. So that is an option. Now, the reason why I say, and it's super important for you to pay attention, is that at the state level, it says 24 hours. However, in the city or the local level, it says 30 hours or 40 hours, depending upon the situation, okay? So employers may provide each employee sick leave. Employees must incur no less than 1 hour of sick leave for every 30 hours worked. Employers may satisfy the accrual and carryover balance if no less than 40 hours of earned sick leave are awarded to an employee. So what I'm getting at is that, you have to give more. Okay, so if you're only looking at the federal, it says then you're fine. You don't have to give anything. Well, you're going to get in trouble. If you look at the state level and you give them 24, you think, yeah, I'm a good person. I gave them 24. You're a good person, but you still messed up. If you give them 40 hours at the local level, then you're a good guy or a good girl. So in that situation, that is what you have to look at. So it's complicated. Okay. And what I would also say to that is that you have to look at it per city that your employee is at. It varies. If you're in Los Angeles, it's not 40 hours like in San Diego, it's 48 hours, okay? So that's where it gets to be extremely complicated and why you have to pay close attention to the actual local requirements, okay? Finally, company responsibility. Now, again, this is the non-spicy stuff, okay? So if you have an aversion to anything that I have said, which is probably the case, and I'm okay with that, and you find this to be very challenging, and you still want to contribute in some capacity, this is where you're going to be a factor. Okay, a lot of the other information that I shared to you today, again, it was touch and go, but a lot of that information is going to be covered by your payroll company, your HR representative, whoever that may be. This, however, is something that you can do, okay? When you are onboarding a new employee, you need to obtain an official offer letter, okay? You need to get their basic data information. So you want to get name, date of birth, emergency contact. This is something that you're going to create, but there are plenty of templates online for you to be able to get this information. Even though, you're having someone else fill out or to do the paperwork or even give you the paperwork, you still have to inspect the I-9 form. So you're the one that has to sign or review the Social Security card or the passport. You have to make sure that they fill out the W-4 forms. You have to have the DE-4 California forms. Those are requirements. Then you have to talk about, does your organization even offer insurance? Oh my goodness, I know, right? You thought you were done with all of the forms, but then you have the ones that you yourself put yourself in. It's kind of one of those, oh man, insurance forms. So is your organization going to offer that employee insurance? There are some times when you're required to. So insurance is a whole other can of worms that I'm not going to get into, but that may be something that if you're looking to hire an attorney or to have someone help you with that, talk to them about the legal requirements, how many hours they have to work, things like that, in order to be able to qualify for insurance and what your obligation is. A disability self-identification form, if applicable, if you're working with government contracts, this is going to be a required form. So it really depends. Private pay, it's not something that you have to, a private organization may not be one. And then any other agreements. So if you deal with proprietary information, non-disclosure agreements, things like that. Again, these are the voluntary ones that you get to choose. Okay, not that you want extra work, but if you do, this is where this would be going. Okay. One of the main requirements of an employer is to make this easy on their employee and to have set policies and procedures, okay? That is why it is my recommendation, highly, 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 highly recommend to have an employee handbook, okay? This is where if your employee is late for work and they show up 15 minutes late and you say, where were you? And they go, well, my other job let me come in 15 minutes late. You can go, hold on page 6 of the employee handbook that you agreed to, 15 minutes, not okay, okay? This is also a way for you to be able to say that the individual has not followed company policies. The more that you can put into your employee handbook on the onset, the more protections you are going to have. If somebody is insubordinate or somebody is not following company rules, if they do not have access to those rules, how are they going to know? Okay, that is why an employee handbook is really critical in order to be able to make sure that you have that. So that way, for documentation purposes, for legal purposes, this should go over sick time, vacation time, PTO, raises, disciplinary action, reviews, promotions, also safety policies, harassment, EEOC statements, anything and everything that you can imagine. This is the one place that you are responsible to provide your employees with that information. So unfortunately, all of that information is all over the place for you. But, again, we're employee centered here in California. You're required, well, not legally, but you should have an employee handbook to organize all of this for your employees, which is going to be complicated. Now, there are templates out there. There are organizations, I know ADP, I believe, actually has a template for you that you can work with. Again, I'm not advocating for ADP. I just need to make sure that's very clear. So I just use them personally, and that's what CAMFT uses. If, however, you have a different paychecks, things along those lines, go right ahead. They are all equally qualified, in my opinion. Okay. Oh, look, we are now at the point where you may begin to think about actually hiring somebody. Okay. So we went through the federal, we went through the state, we went through the local. Now it's your responsibilities. All of that was the behind the scenes work that goes into hiring an employee. It is long, it is arduous, it is complicated. And now is the fun part. You get to actually create a job description, advertise the opening, interview, and hire. I say that's the fun part because, we're at least something positive where you may be able to see some fruit from your labors. With that said, if you've ever hired somebody, there's quite a few different laws in this area about even interviewing, what questions could be asked, what policies in place. So it's not the easiest thing to do, but at least, we need some light at the end of the tunnel. And this is where we're at, and this is where we're going to stop with regards to positivity. Okay. So that's it. That's hiring an employee. Literally, that's why I said hiring an employee is complicated. And I went through it. That is a high level overview. And I know that was a lot of you were like, really a high level. Okay, that was a lot. I get it. But at least you have a place now to refer back to. If you are starting out, guess what? It was scary, but that's what you're going to have to look at. If you are experienced, this is something where you can refer back to and maybe even say, okay, what am I doing currently? Am I following this? Do I have a retirement plan? Do I have insurance? Do I have this form? How long do I have to keep these forms for? Okay, so that is what that section of the presentation is for those individuals. So I know that was a lot. We have 2 additional sections and we have about 45 minutes. So I have time, and I'm going to pause right here so I can get a sip of my soda. Is there any questions that are in that section? Again, I apologize already, and thank you for those that are answering questions, and thank you for those that are being patient with Anne. I saw some of the questions in the Q&A at the break, and they are complicated questions. So, Anne is doing the best that she can, and kudos to her for all her hard work. So thank you, Anne, in advance.
No, it's my pleasure. We don't actually have any open questions. I got through all of them.
Oh my
so
gosh.
If you're interested in looking at the questions and answers, you can look in the answer tab in the Q&A box. But yeah, you're doing great, Luke.
Okay, thank you. No problem. So now that we have gone through hiring an employee, we have to talk about ending an employment relationship. Because you remember at the onset, we said that you cannot start a business without thinking about ending the business. You cannot hire an employee without thinking about ending the relationship. So this is ending a relationship, okay? So We do have an article on this. So if you are interested in learning about ending an employment relationship, you're an associate who's about to start their private practice and they're worried about their clients, that's a great article to be able to look at. It's also a great article to look at for your employer to kind of figure out, okay, what do I need to do? How do I need to do this? What should I do? What's CAMFT's recommendations? That article will go over it. You simply just need to type in ending an employment relationship on the CAMFT website and it should be there. Okay. Now, there are different types of relationships. There are volunteer or intern. There are 1099 stipend recipients. There are independent contractors, and there's W-2 employees. So it depends upon the actual type of relationship as to the legality of it in this context, as well as what your requirements are. Okay. Volunteer. Typically, the one-time volunteer labor is allowed is when the organization is a not-for-profit organization. It should be clear that there is no employment relationship and the person is truly volunteering without any form of coercion to complete the task. Generally speaking, a for-profit private organization is normally not allowed to accept volunteer labor. The Fair Labor Standard Act of 1938 states that any employee of a for-profit company must be paid for their work. While the FLSA does not consider interns employees, the intern must be the primary beneficiary of the arrangement for an internship to be legal. Essentially, what that means is that if you are starting a nonprofit charitable organization, and that's the business structure that you want to set up, awesome, go right ahead. And if you want to bring on volunteers, you're probably going to be okay. I say probably because, I'm a lawyer and I need to have an escape if need be. If you are a for-profit private organization, you are a professional corporation and you're looking to bring in volunteers, I would think twice, okay? I think it is going to be very difficult for you to be able to have volunteers lawfully in that scenario, okay? Federal standard for volunteer classification, a licensed individual will generally not be allowed to volunteer their time and services at a for-profit private sector employer. This is directly from the U.S. State Department of Labor. And as you can see from right here, let's see if I can zoom in. Under the Fair Standard Labor, employees may not volunteer services to for-profit private sector employees. So, it's pretty clear in this area that it's not going to be allowed. Can a for-profit have interns? Maybe, if it can pass the primary beneficiary test. Okay, so if you are a for-profit organization and you are wanting to have interns, and I am not talking about trainees, because trainees are not allowed to work at for-profit. You are wanting to have, let's say, an undergraduate intern at your organization. They are interested in pursuing a bachelor's degree in psychology, and they are wanting to get some experience at a therapist organization, and you don't want to pay them. Then maybe you can bring that person aboard, okay? The intern and students, however, may not be employees under the FLSA if they are not, it doesn't require compensation, and you have to pass this primary beneficiary test. There is, it's quite complicated. There needs to be some sort of formal education. They need to be set up with a school. It needs to be for essentially their benefit, okay? The primary beneficiary test really wants to measure who's benefiting, okay? If you bring that intern in from San Diego State University's undergraduate psychology program, are they going to benefit, or are you really benefiting? And you're just finding a way to get free labor, okay? That's what that test ultimately looks at. If you are the primary beneficiary as the employer, it's a problem. If your intern is the primary beneficiary, then it may be okay. California law on for-profit volunteers. California Division of Labor Standards Enforcement has its own set of rules surrounding the legality of an unpaid internship. If your business wishes to take on an unpaid intern, you must meet all of the following requirements. The internship must be part of an established course at an accredited school. The intern must be trained to work in a specific industry. The intern must not displace any regular employees. The internship must be supervised by a school or agency. The intern must not receive any benefits or health insurance. And the intern must be aware that the internship is unpaid. So what does that mean? Essentially, that means that not only do you have to pass the primary beneficiary test at the federal level, but you also have to pass it at the state level as well. And I just want to make sure that we're clear, because I feel that there may be some questions lingering. This is for individuals, not for trainees. This is not for associates, okay? We already established that, volunteering at a for-profit organization is not appropriate in those contexts. This is for those undergraduates who are in school, who are looking to develop skill sets or interest in the fields. Okay, so it's a little bit different. Okay, if for some reason you bring aboard a SDSU undergraduate psychology student and they are not receiving credit for it, they are just, helping out, they are answering the phones. If for some reason that relationship sours, it's a problem, because they should have been potentially should have been classified as an employee. In the event that that does take place, you may be on the hook for minimum wage, back time, break time, sick time, vacation time, anything that a normal employee would have. Okay, so that's why it's really important to pay attention in this scenario. Okay, 1099 stipend. Okay, when is hiring an unlicensed individual and paying with a 1099 allowed? Okay, I want to make something very clear. The general rule is that if you are a trainee, if you are an associate and you are being paid, the law says, at least with the Business and Professions Code, you may not be a 1099 contractor. Now, there is one exception to that rule, and that is going to be found in Business and Professions Code 4980.43.3. Okay, that's where it is. I have it right here. And it says a trainee or applicant for licensure who receives a stipend or educational loan repayment from a program designed to encourage demographically underrepresented groups to enter the profession or to improve recruitment and retention in an underserved region or settings shall be considered an employee, even if you pay them with a 1099. Okay, so it is feasible in this scenario where you have somebody who is receiving a stipend or an educational loan, to provide that stipend to them or that educational loan in a 1099 format. Okay, they will have to submit that to the BBS. They will then have to submit why this program meets the requirements of serving a demographically underrepresented group, or to enter the profession, and retention in underserved region. But it is something that they are allowed. That is the only time when the BBS will say, okay, a 1099 is okay. I would be extremely, extremely cautious in this area, because if you are wrong, none of those hours will count. Okay, so it may be something where it's, I don't want to say buyer beware, but it is something that you can do, but in unique situations. Okay, so what about just independent contractors? Okay, can I hire somebody, and we don't even have to talk about associates or trainees, can I hire somebody on as an independent contractor? This is a 6-hour presentation on itself. Okay, we do have several articles because there have been several changes in this area. The main one that I would start with, if you're interested in bringing somebody on as a 1099 rather than a W-2 employee, is this AB5 in the Independent Contractor Psychotherapist in California, written by our executive director, Kathy Atkins. It's a great article. It goes over the basics. It talks about how we have moved from the Borrello standard to the Dynamex court case. We had this huge factor test, which made it very easy to bring somebody aboard as an independent contractor, and have really restricted it. Okay, the ABC test is just this. You are able to bring a person on as an independent contractor, usually in this case a licensee, just to be clear, if the worker was free from control and direction, the work was performed outside the usual course of business, and the worker was engaged in an independent business. Where it gets stuck is the work was performed outside the usual course of business. What does that mean? Great question. It is very complicated and it has not been fully litigated, so I really can't tell you. It is something where it is going to be on a case-by-case basis. The way that I always look at this is, if I'm a therapist and I am wanting to bring aboard a plumber, okay? I do therapy, he does plumbing. His work is outside of what my therapist business usually does. Okay, as long as everything else matches up, I may be able to bring him aboard as an independent contractor. If I am a therapist and I bring aboard another therapist, well, if I do therapy, they do therapy, there may be an issue. Now, that is a clear oversimplification, so I would like to make a mention that is a very simplification. There are additional exceptions to the rule. If you're interested in learning more about independent contractors, by all means, take a look at these articles. Talk to an employment attorney. I cannot recommend that enough. But in that situation, it may be problematic. Now, I have heard of some businesses actually talking about, well, I do EMDR and I'm trying to bring aboard a play therapist. Will that work? Maybe. I don't know. And I don't think a lot of people would be able to tell you one way or the other in that situation. If you have somebody, if you have legal counsel and they want to take that risk, then go right ahead. But it's a complicated question. There is, because this is such a new law, it came out in 2018, and then there was a legislation in 2019. There was more legislation in 2020. It's made it extremely complicated. And so there really isn't a good answer because, as you are well aware, 2020, guess what happened? COVID. And so then we had to deal with COVID. And, we had a whole large issue with employment. So we kind of relaxed some of the rules. We've now kind of made it gone back into effect. So, there's going to be litigation that comes out. The Department of Industrial Relations is hopefully going to make decisions so that way we have a better understanding. But that's where we're at right now. It's a dangerous kind of area to hire somebody on as an independent contractor. You definitely can't bring aboard a trainee or an associate or an application for licensure. So this person has to be licensed. You may be able to bring them aboard if they are an outside, you want to bring your HR representative, you want to bring aboard, administrative assistant. That may be able to be an independent contractor. It just depends. I will tell you that if you are looking to bring an independent contractor aboard and you are just starting your business, I cannot strongly recommend enough to talk to an employment attorney. Here's another article that we have on this topic. So again, I am sure there's probably questions about independent contractors. This is not the presentation to ask those questions, only because I can only touch on it for so much. If you do have specific questions, Anne will hopefully try to answer them in the Q&A. You call a CAMFT. We may just refer you to an employment attorney just because there's a lot that, even we as attorneys may not be able to answer because it's going to be so specific. And since we can't provide you specific legal recommendations, it may not be something that we answer. What I will say is that, those are the relationships that are very unique. A W-2 employee, that is very common. Okay, so that is a relationship that is pretty common. That is something that you should be familiar with. That shouldn't be something that, is unusual for you. Because if you generally have had a job before, you most likely have been a W-2 employee, okay? This is the most common. Just some of the differences, work hours are scheduled for W-2s. They're not so much with independent contractors, so there's a lot more flexibility. W-2s, you go in, you have a set position, you have a set job, you set tasks, certain things are provided for you, you have a single employer. Independent contractors, your work schedule's up in the air, it's case by case. You can reject the work if you don't want to do it. You have more autonomy as an independent contractor, hence the word independent, than a W-2 employee, okay? So those are the different types of business relationships that you are hiring, okay? Legal considerations of separation, okay? So most relationships here are W-2s, okay? If you're an independent contractor, some of these may not apply to you, okay? This is just going to be for generally an at-will employee that is a W-2. At-will means, in the absence of an employment contract stating otherwise, an employee can quit or be terminated for any legal reason at any given time. This allows an employee to depart an organization and an employer to end their relationship for any reason or no reason, so long as termination is not illegal. Okay. Where it becomes a little interesting is when an employer tries to put in a contract that says that you have to give 30-day notice when you're quitting. Unfortunately, that's just not really enforceable here in California. The labor code doesn't require that. Now, it may be fine to have in there and it may serve as a scare tactic, but I don't think that's something that you can legally enforce. So do keep that in mind. With an at-will employment or an agreement, you can terminate your employee for any given legal reason, and we'll cover that more at any given time. So, I spoke to somebody the other day who said, I only fire people on Fridays. And I said, well, why not Thursday? And they said, well, I can't fire them on Fridays. And I go, why? And they go, well, I just learned you can't. And I go, well, no, that's not a rule. You can fire them at any given time for any given legal reason. Now, but the inverse is true as well. They can quit on a Thursday, they can quit on a Wednesday, they can quit whenever they want. Now, is it best practice for an individual who's departing to at least provide some sort of notice? Absolutely. Standard practice is 2 weeks. Best practice, a month. So that way you have time to transition your clients. However, that's really going to be dependent upon the two of you as an employer and an employee. As an employer, if you are not nice to your employee and they've given a 2 weeks notice, they can quit at any given time. Same thing as an employee though. If you're not nice and you're not nice to your employer during that period of time and you're supposed to show up and you don't, they can say, thanks for the 2 weeks notice, your last day is today. And that's perfectly fine as well. So keep that in mind with a at-will employment relationship. If an employee resigns or quits, okay, absent an employment contract, they can do so at any given time. An employee who does not have a written agreement for a definitive period of employment and who quits without giving prior notice must be paid his or her wages within 72 hours. So Ann is my boss. If I tell Ann, I quit, no, that's not real, Ann, don't take that as serious. She doesn't, she can take that I'm quitting, but she doesn't have to pay me until 72 hours have commenced, okay? If the employee gives at least 72 hours notice, so basically I am quitting today and my last day will be next Friday, okay? At that time, you do not have to pay until I actually is my last day, okay? So that's the difference between the two. So it's really important to make sure that you understand that distinction as to, how much time is given and how much notice is given when an employee resigns, only because there are legal obligations that are triggered at that time. Okay. What happens if an employee is terminated? Okay. Absence an employment contract stating otherwise, an employee may be terminated for any legal reason at any given time. Employees who are discharged must be paid all wages due at the time of termination. All wages include any earned and vacation time. We talked about sick time earlier, vacation time, PTO, those are discretionary issues that the employer gets to choose. Sick time is not. If you do award your individual's vacation pay, those are viewed as earned income. So you are obligated to pay that. So if you tell your employee, I'm going to give you 3 weeks and I'm going to, give you 1 week of sick time, guess what? At the very end, even if they, have worked an hour, if you gave them that 3 weeks of vacation up front, yikes, you now have to pay them for 3 weeks plus 1 day. So it's really important that you take into consideration this vacation aspect of it as well, what you give your employees. Be friendly, be competitive, but also be realistic as to what your requirements are, because you don't want to have to pay a lot of money for a person who just started. Two other things that I want to talk about. I keep mentioning employment contract stating otherwise. Basically, what that means is that if you have a set contract, let's say for a year, think about it as like a basketball player, okay? When they play basketball, they sign year contracts. It could be a 5-year contract. It could be a 3-year contract. Those are obligations that you have to pay. Those are really unusual in this profession, maybe in the school districts or the school areas where they're for set periods of time or for contracts, maybe for school years, but that's not usually what we have. If you do have those scenarios, that's going to be a unique situation, which unfortunately I don't have time to be able to answer. Call in or talk to an employment attorney, but usually there's a little bit of a different rules in that area. Employment termination, okay? When you are terminating an employee, it is a best practice to have a paper trail. The reason being is because you never want to fire somebody for inappropriate reasons. And we'll cover what inappropriate reasons are in just a moment. But as far as inappropriate reasons, if they are late, you want to document that. If they are not doing a good job, you want to document that. The reason why you want to do that is because you do not ever want to be charged with a unlawful termination legal claim. Because if the less that you have to be able to support that you terminated them lawfully, the more likely that you are to get into trouble. So I would definitely keep that into consideration when you are making a termination. Now, it's not a legal requirement. There is no, you have to have write-up 1, write-up 2, write-up 3. That's a misnomer. It is something that is just best practice because it serves as a legal protection for you and your business. Okay. CAMFT Code of Ethics, on this specific topic, we do state that we would recommend, or I wouldn't say recommend, the CAMFT Code of Ethics highlights the need for supervisors and educators to provide supervisees with periodic performance appraisals. Even the BBS has created new laws where there needs to be annual reviews. Those are a great place for you to be able to highlight the need for performance improvement. If you are not seeing that performance improvement, it's a great way to terminate a person. You're not terminating them for unlawful reasons. You're terminating them because they have not been performing. There has not been improvement. And by having those annual reviews, those write-ups, you're able to clearly document that. Okay, employment termination. So this is complicated. I say that, I've said that like throughout the time. I feel like I need a button or a recorder so that way I can save my voice. But employment termination is complicated when you are terminating a person. Reason why we want to have documentation is because, there is definitely a benefit because there are so many protected categories that you could inadvertently stumble upon. Race, sex, pregnancy, medical condition, religion, national origin, sexual orientation, gender expression, all of those are generally protected. So you cannot fire a person for that. Some of the new things that have come out is grooming practices. So a person's hairstyle. If you find that a person's hairstyle is not to your liking and you think that it's something that you want to terminate them for, think again. What they are wearing, which is, religious in nature, you want to terminate them because you don't like what they're wearing, think again, okay? So the reason why it is recommended, highly, highly recommended in order to be able to have documentation to be able to support your termination is to make sure that you are not terminating an employee unknowingly or unconsciously being biased or being directly biased. And in either of those situations, that is highly inappropriate and you should not be terminating an employee for those purposes. I always recommend having an extra set of eyes. If you are a single person and you are firing a person, it never hurts to consult with a colleague. You don't have to give specifics about that individual, their name or anything like that. You can give just basic information. Would you do this? What documents do you have? All of those are going to be extremely beneficial in making sure that you're not violating any labor laws. Okay, practical considerations. So you're terminating a person, your last paycheck, things like that. Just some things to consider. Returning company policy. company property, excuse me. Do they have a laptop? Do they have a cell phone? Do they have access to your electronic health record system? Those are all things that you need to consider when you're terminating an employee. I can't tell you how many employers that I've talked to who have terminated an employee. It has not gone well. The employee is irate, and they go in and into the electronic health record system and begin deleting records. Yeah, that happens. It's all good until something bad happens. And in that situation, there's not much that you can do. You can try to reverse it, but the employee is on their way out. It was your responsibility to make sure that they no longer have access to that. So really think about what they have access to, what they can get you into trouble with. I understand that a lot of people are empathetic in this area where they've had a positive relationship, but they also have to think worst case scenario, and I think that's where either talking to an attorney, because that is where our mind goes constantly, is worst case scenario, or talking to a third party or having an HR representative can really benefit an employer in these scenarios. Okay. Also things to think about: final paychecks, employee benefits, because if you offer insurance, you're going to have to eventually cut that off, and then referrals and references. And that's for both individuals. So both the employer and the employee. If you provide no notice, you just quit on the spot. I mean, they're not going to give you a good referral or reference. Now, there are laws surrounding what they can and can't do, but they can, address certain situations like, would you rehire this person or not? So keep that in mind when you are separating from an organization. The one thing that I highly, highly recommend you avoiding at all costs is inappropriate behavior. Don't say bad things about each other. I mean, at one time you liked each other because you hired that person on, you decided to work for that employee. Do not begin to talk derogatory about each other. The other consideration that a lot of people have in this period of time when the relationship is souring and ending is they're not happy about something, so they want to complain to the BBS, which I am not trying to withhold you from doing that. But to me, that is the MAD decision, or the mutually assured destruction. Because guess what? If you complain about me, I'm going to complain about you. So you're not perfect. The employee is not perfect. The employer is not perfect. People make mistakes, and nothing is going to go 100%. As you can see, there are so many things in this presentation, so many areas that you can go wrong. I mean, you can forget a pamphlet, and things happen. And ultimately, at the end of the day, by intervening and having third parties kind of intervene in your situation, it escalates rather than de-escalates. And usually in situations like that, introducing third parties such as the BBS may not be advisable because, while you're mad, it may lead to mutually assured destruction. Okay. Defamation. This is what we see generally in this area. My employer is horrible. Let me tell everybody that my employer is horrible. Let me tell you, my employee is horrible. My employee is horrible. Don't do that. I mean, again, it's not beneficial. It's not going to help you. It may feel rewarding at the time and may get it off your chest. But as therapists, you speak to that issue at your next appointment that you have with your own personal therapist. That is the better place. Talk to friends about it. Don't post it online. Don't tell clients about it. Things have a way of trickling down. Anytime when you say something like that, it can be used against you. Defamation, libel, slander, they are civil torts, and there are something that you can sue somebody over. And so I would hate for, again, this to escalate, for you to say something, for you to post somewhere, and it cause a problem for either individual, because then at that point it's really problematic, because it could be impacting the employee's future as well as the employer's. Okay. Oh yeah. Yeah, you've been thinking about yourself the entire time. it's probably best to think about the employee at some time when you're leaving an organization, right? So I know this is really small in comparison to the rest of the presentation, but it is important. So just because you have issues going on with your employer, just because you have issues with regards to your employee, doesn't necessarily mean that there's not other issues going on with those that you're representing. So be sure that when you are departing an organization, that you take into consideration your clients' needs as well. Your clients have your clients are going through things. That's why they're coming to you to address their issues. They don't need to be wrapped up in your issues. Self-disclosure, over-disclosure, those are even ethical considerations and even potentially unprofessional conduct. So be careful with what you say with your clients. Now, that doesn't mean that you can't let them know that you're departing the organization, but that does mean that you don't need to be saying the reason why I'm departing my organization is because my company is committing fraud and they're not paying me and, bad thing. You don't need to do that. And also, as an employer, you also don't need to say, well, the employee quit on the spot. They've been a horrible employee. They haven't been treating the clients right and blah, 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 blah. Whatever that may be. Either way, neither one are good because ultimately that's not going to sit well with the client. So even if you address your own issues by, bringing in another third party, again, escalating rather than de-escalating, it's a potential issue. So clients need attention. Think about the code of ethics. Think about termination plans. Think about continuing with the departing therapist, continuing with the former employer, serving them completely during that period of time that you're transitioning, and ultimately think about the client record. Okay, don't see any questions, and we do have only 10 minutes, so I am going to finish up real quick on this last topic, which is, hey, records. Remember at the onset, I said, anytime you start a business and you are thinking about seeing a client, and you do, even if that business does not work out, you are stuck with that business. It will follow you for at least 7 years. And this is why. It's because the record. There are legal obligations that you have to maintain records for a certain period of time. And we will talk about that in just a moment. So what do you have to have in a client record? Well, the law doesn't say specifically. It doesn't say you have to have A, B, C, D, E, F. There's definitely something about having an informed consent. There's definitely something about having an intake paperwork, having emergency contacts, having a treatment plan, having notes. I cannot stress that enough, having notes, because there are plenty of therapists out there that do not keep notes. I do not recommend that. I think that goes against quite a few different regulations. So, altogether, there should be notes, even if you're just starting in this area. And those are things that should be kept in the clinical record. Again, intake paperwork, copy of the informed consent, authorizations to release, office policies, fees, payments, all of this is going to depend upon the organization. If you're a free organization, payments are probably not going to be something that you're going to need to keep. If you are, you're not going to be billing insurance companies, you probably don't need to keep that information. So it is going to be site specific, and it's going to depend upon each organization as to what is going to be in the record. There's no right or wrong answer. The more that you can keep, probably the better in this situation, just for documentation purposes, because there are many ways that those documents can be used. And so I think it's definitely best to have it. I do want to go over real quick, just because we have a little bit of time, the difference between progress and psychotherapy notes. So progress notes are what generally needs to be kept in the clinical record. Psychotherapy notes, not so much. You can. Oftentimes, these words are used synonymously, and they're not the same thing, okay? Progress notes are designed to inform staff about patient care and communicate treatment plans. They're generally in SOAP formats, and these notes must generally be produced when there's a subpoena, okay? So when somebody requests their copy of their records, these are the notes that you generally provide. Psychotherapy notes are different. Psychotherapy notes are also called process or private notes, these are usually your notes that you're taking in session. You're scribbling down things as the individual is talking to you. I know that there's some psychotherapists out there that doodle and they do tic-tac-toe and I need milk, or, this is countertransference and, things like that. They're not generally in a format that is usable other than for the actual provider themselves. In that situation, psychotherapy notes, as long as they are converted or used in some capacity to create a progress note, do not need to be kept. If you decide to keep psychotherapy notes, great. Psychotherapy notes are generally not discoverable from the client. So if a client requests them, they are not something that needs to be produced. However, if you receive a subpoena for any and all documents surrounding this client, that is where it's different. So this is something that a lot of people are unaware of, that progress notes, clients are entitled to. Psychotherapy notes, clients are not entitled to. Subpoena, both. Progress notes and psychotherapy notes may be discoverable in a subpoena-based situation. So keep that in mind as to if that is something that you are wanting to retain. Okay. Psychotherapy notes, if any of you are interested, and again, you need additional reading material because publication 15 wasn't great, Family and Medical Leave Act, OSHA, any of those documents weren't going to put you to sleep, and you need something more heavy and more sturdy. You can begin to start reading Supreme Court cases, Jaffe v. Redmond. That's going to definitely put you to sleep. It's definitely an interesting case. So if you haven't read it or you haven't read it in a while, that may be something that, just for fun, why not? Okay. Who owns the record? Okay, so you set up this business, you end the business. Who owns the record? Well, the physical file, meaning the actual pieces of paper that you have, those are owned by the therapist or the business. The content, what is written on that page, that is owned by the client. Okay, so the client is able to, in some situations, be able to obtain a copy of their record. They are not handed the actual physical file. The employer in this situation generally should keep a copy of all records of any client for liability purposes. And what I mean by that is that if you're an employer and you can potentially be sued, you would be at a real disadvantage if you left your employee have a copy of those records and you didn't keep a copy for yourself. Because guess what? If the relationship sours and that individual is no longer an employee of yours, you may be adversarial in that capacity. And without that clinical record to be able to support what you did or what that employee did, it could put you at a disadvantage from liability standpoint. So as an employer, if you have employees, I would always recommend making sure that you maintain the record. Now, that does put an onus and an obligation as being the custodian of the record, but you will be in a better position later in the event that something did rise. Okay. And how long could that occur? Well, 7 years. So as an employer holding on to the record, you are obligated to keep it from 7 years after the date of separation. So what I mean by that is if the therapist stops treating in January of 2017, your obligation is to keep that record until January of 2017. Okay, so it's 7 years that you have to keep the record. The only exception to that rule is if you're seeing minors. So if you're seeing minors, you have to keep it for 7 years after their 18th birthday or until that minor reaches 25. So an example of that is if the therapist stops seeing a child when he is 10 years old, the obligation is for that therapist to keep the record for 15 years or until they reach 25. So that's a huge obligation. That is a huge burden to place on an individual to be able to maintain records for that period of time. Just imagine you started this business as a bright new therapist. The world is your oyster, and you see one client and it's a child, and you realize, yeah, it's not for me. I don't want to be my own boss. This is too much. There's too much going on. Guess what? Sorry, you're now obligated to keep that record for 15 years. So, I cannot highlight this enough. When you are starting a business, it is imperative to think about what you are doing. I covered a lot. I get it. And if you're overwhelmed, I apologize. Please feel free to take a look at this presentation at any given time. It's my understanding that you have been given slides. The CAMFT legal line is open. I'm happy to answer questions. I'm sure my colleagues are happy to answer questions as well. It is a complicated topic. There is a lot that goes into it. But the one thing that I can tell you is that the more that you expose yourself to this, the more that you have knowledge of this topic and the more that you plan, the better you are going to be. It is going to make your life easier, because when you are sitting here today opening your business, your actions can last for the next 15 years today. So that's not to scare you. That is not to dissuade you from doing this. This is great work. There are a lot of great therapists. There's a lot of people out there who own their business, love it, would never change a thing, but it is something that you need to know what you're getting yourself into. And hopefully this presentation did just that. It exposed you to the big pictures, it exposed you to some of the small details, and it also exposed you to what your legal and ethical obligations are. So that's my time here. And do you have any questions? I think we have like 1 minute. I can maybe throw out a question. Otherwise, I'll end now.
There are some questions Q&A that we can get through after, but if you can answer one, let's see here. Are CPS and APS reports made by the clinician discoverable through a subpoena or court order? Is it beneficial to keep them from being discoverable? And what is the simplest way to do that?
Yeah, so if you put those records in the clinical file, then they are potentially discoverable, which is potentially problematic. So I would definitely advise keeping them separate. Are they obtainable by a court order? I would probably say yes in that situation, because the judge does ask for that. So, it really just depends upon your unique situation as to the discoverability of them and how you store them separately. But keeping them stored separately and then a court order is definitely a definitive yes.